Give me coffee in the morning, gotta have the caffeine. Wake me up, shake me up, dip me back on the seat. Must shit to shit, set a feeling so alive. Coffee in the morning, it's the best way to survive. Woke up in the morning, sleepy eyes yawning. Jumped out of bed, started the day, opened the curtains. Felt the cool breeze, the sun shining on my face. But something was missing, I needed my job to chase. Give me coffee in the morning, give me coffee in the morning, gotta have the caffeine. Wake me up, shake me up, dip me back on the seat. Must shit to shit, set a feeling so alive.
There we are. Good morning. Good morning. Welcome in, everybody. Butterfly, welcome in. I was like, I'm running a little bit late this morning, but it's all good. I got my coffee, first cup. Good morning, Dolphin.
Morning.
Hey, I had, look, I've been sleeping a lot later than I was used to. And like, I woke up on Saturday morning and realized it was past time to stream the trial. And I was like, oh no. And I was like, oh, wait, it's Saturday, right? So that almost happened this morning as well. I was like, wait,
Oh, yeah.
what time is it? Scramble to get everything ready and get my coffee, but we made it. Um, Fans are spinning over there in Canton.
Oh, boy.
Okay, let's see. Yeah, hopefully we'll get through this witness and get on to some others today.
Mm-hmm.
I'm ready for that part of it. Well, they're going to finish with Dr. Russell. I guess she's still coming back to the stand this morning. I don't think.
Oh, yeah.
Remember they were dragging that shit on Friday or
Mm-hmm.
yesterday or whatever. I got hearings and trials all jumbled up in my head. Um, I had to watch Lori Val. Well, I didn't have to. I did it for shits and giggles because I wanted to get caught up. So yesterday afternoon, I ended up watching. They brought her into court to start court to finish out their jury selections, and they had to
Mm-hmm.
wheel her in a wheelchair. Miss Lori with a capital R doesn't feel good. So
I saw some clip of her questioning somebody, and it was a woman, and she said, she asked her, how did I know why you were coming to me, or something like that. I think she was coming to inform her that Charles was dead, but she didn't want to do it in front of her daughter. And just the exchange back and forth, I was like, this woman is an imbecile.
So you didn't. You should see. I wonder if you saw Nancy Joe's exchange and then Kay Woodcock's exchange with her. Those were epic. They, were, they took the opportunity to get what they needed to get in at Lori, and it was great. It was fucking great. But yeah, Miss Thing is over there. She does sound like she has a cold. There is something going on, but here's the thing: we all got to pull up our big boy pants at some point, go to court, right? I don't know. I don't. If it's like she's milking it as a delay tactic as well, but
Mm-hmm.
there's also that thing. The judge was questioning her about did she put in for orders to go to medical, and she said she did, but what everybody don't realize on Friday when she was sick, Lori couldn't leave and go to the little ER like we could and get her meds and go home and get better. Lori had to go back and wait for the infirmary to get to her. So I don't know. The judge gave them until Wednesday morning because they were in the middle of seating a jury when she pulls all this. So now they're at the point, what do we do, right? So the judge gave her till Wednesday morning. So she says back to the judge, well, what are you going to do? Have them come into my cell and haul me out of there again? He said, he's like, I will exactly do that. And then she's like, well, you could just come down to the jail and see for yourself that I'm sick. He's like, no, I think I'll pass.
Mm.
I was like, my God, these courtrooms are becoming very ballsy, people. It's almost like a comedy show for some of them.
Yeah.
right, Butterfly? No, she's never gonna put herself on the dark list. Um, nah. She just got up there sounding so pathetic and you know, wanted to be seen and heard. She doesn't like to disappoint people, she said, so she can't be positive she's gonna be better on Wednesday. You don't want to disappoint people. You mean what really is going on in this trial, Lori, that's very different from all of your other trials? This victim is still alive to face you. That terrifies Lori. So, for all those wondering what kind of game Lori's playing, that'd be the game right there. Brandon is alive and is going to confront her on the witness stand, and she knows it. She was terrified to confront Kay. Kay's like, oh boy, here we go. Bring it, Lori. Yeah, because they believe Butterfly that it could be part of a stalling tactic on her end because she didn't get her way when the judge didn't get to have to recuse himself. So that messed Lori all that messed up her mind game right there. Lori didn't get her way, not once but twice. So the next thing we know, she's all sickly and in a wheelchair and can't do anything. So the judge did tell her, no matter how long you drag this out, I will still be your trial judge. So was it just a tactic to get him removed? In her mind, if we don't get this in, he's got other obligations. They'll assign a new judge. I don't think a new judge is going to change anything for her.
Oh.
What did you see?
McDonald's brought back their steak, egg, and cheese bagel.
She- oh, nice.
Mm-hmm.
I was yesterday. I got well. I did. I was kind of not. But
Mm-hmm.
we have this one tiny grocery store down in town, and I didn't feel like going like 100 miles, and I'm exaggerating, but 100 miles to get to the damn real grocery store. So
Oh
anyway,
yeah.
I went to that one yesterday afternoon, and they don't have half of what I want ever because it's such a tiny little rinky dink one red light town grocery store. Do you know what I mean? That kind of
Oh yeah.
yeah, and it's like the selection's not there that I'm used to, and they didn't even have English muffins, girl. I was like, "What kind of store is this?"
Yeah. What kind of store is that?
I know they only had like blueberry bagels and everything bagels to choose from, and they were the I don't know the brand, the price. I didn't trust it. I was like, I can't. My brain is a little weird when it comes to stuff
Mm-hmm.
like food wise, and I was just not. I was like, man, just let me get a few things and fuck it. I'll just have to go order my shit. Have my
What
son
is
go pick it up.
McDonald's on? Hot cakes and steak at McDonald's.
Remember back in the day, I don't know, Hardee's used to have the steak biscuits, and they were good. I've
Yeah,
never,
but I'm just like McDonald's.
I didn't know McDonald's had a steak biscuit, which I don't eat McDonald's often, so
Well, the only thing I thought that they had that had quote unquote steak was this bagel. But
mm,
under the home style breakfasts, they have hot cakes and steak
hmm,
or big breakfasts. Yeah, with hot cakes and yeah. Oh, that's interesting.
I couldn't tell you what's on their menu anymore.
Yeah, yeah. I try not to go to them too much, but
No, my son still likes to go to them every now
oh,
and
it
then.
says currently unavailable.
He likes nuggets, but I don't do McDonald's nuggets. We had a bad episode back in the 80s one time, and so, yeah, I can't do McDonald's nuggets.
What? It says currently unavailable.
Steak is not available today, Dolphin.
No, all their bagels.
Mm,
Everything under their bagels.
we got a bagel shortage we're not aware of.
Yeah, wait, what in the world?
Like, what in the world?
This is my second day of trying to get breakfast that,
Since your new,
I'm having an issue.
since your favorite place closed,
Hmm.
well, we don't like the breakfast episodes. Gosh,
Oh, that's crazy. Oh, God.
she's like, I'm going to panic if they don't get this
I am.
together.
I'm like,
What am I gonna do?
do I have to get up?
Oh man,
Do I
right?
have to drive somewhere? Oh,
The struggle
God.
is like that defeats the purpose, right? You might as well get up and go in the kitchen and make an egg.
Oh, girl, I have nothing in the fridge that,
It's just like
yeah.
I'm forced to get up and drive. Uh, I don't like being
Wow.
forced to do things either. I'm like, nah, I'll just starve. It'll be okay. I'll talk myself right out of something. Well, it'd be easy if it was close by. If it's so much easier to avoid all that if you don't live near it. But then again, it has its downfalls. There's many times I'd like to sit right here and order myself up something and can't do it. And it's like, damned if you do and damned if you don't.
Yeah, I should have ordered some groceries, but I did not.
I have to order. I've been doing trial groceries since I've been covering Lori's trial with. Um, uh, sorry, I was reading something. I had to go stock up on what I call trial groceries, stuff that I can make quick and easy but still good.
Oh, yeah, yeah.
Quick and easy breakfasts and lunches, and then I have my dinners are pretty easy. I'm practicing for getting ready for the Idaho trial because we're going to be sitting here for months apparently
Oh, yeah.
trying to navigate a schedule with that one. But I think the judge will run a tight enough ship that we'll all be okay. We'll figure it out as we go for certain.
So this is weird because it's on DoorDash
Yeah.
for the same McDonald's. Huh. That's weird.
What was the other one? Uber you were looking at or something?
No, the actual McDonald's app.
Oh, gotcha.
That's very weird. Okay. Sorry, I'm just gonna put it in through DoorDash then.
We got a Culver's here for the first time last year. They got pretty good stuff.
Culver's. Culver's. That sounds
Hmm.
familiar.
Yeah, they got really good hamburgers. They got all kinds of amazing milkshakes and stuff like that.
Oh yeah, yeah, yeah,
Yeah,
yeah. I think I've had one on the road.
yeah.
Excuse me. Let's see.
Good morning, Sajoy. Welcome in, Miss Sunshine. We still have the OnlyFans spinning, guys.
Yeah.
Yeah. Little Miss Combative lady from yesterday was on the stand. Man, ugh, some of these witnesses. Butterfly says Culver's is great. Love their ice cream. You guys have them there too. Like they're from out of Wisconsin, I want to think. I've eaten there like my kid likes to go there, and so I got there, ate there a couple times. It was good. I used to deliver that a lot when I was at DoorDash. People always like to get the Culvers, but I didn't like Culvers because they want me to go in there and hit confirm pickup, and I look that irritated me every time. It's like quit accusing me of about to steal this damn food. So annoying. Whatever. It's a personal issue. It started happening at more and more restaurants. Can you confirm you picked it up? Can you shove it right up your? Never mind. Because I guarantee you, I'm about to go deliver it because I'd like to get paid to take my ass to the house.
Yeah.
I don't got no reason to steal these people's food. Except that one time, this one lady ordered a ton of pizza. Like it was a ton of pizza. And something happened with the payment method, and she had to reorder everything, and they'd already made it and give it to me to put in my car. It was a whole thing, and I'm like, "Well, what do y'all want me to do with all these pizzas?" And they're like, "Have at it." I'm like, "Okay, I literally had a back seat full of pizzas." So I took some down to my kid because he had little brothers. I'm like, hey, y'all need some pizza for dinner? I'm on my way. And then I brought the rest home and gave to my other kid and my grandson. I was like, that was an easy day, but it was a ton of fucking pizza. Had a one lady one time had me deliver her KFC to the wrong address, and she felt so bad because she forgot to change her address. And I was like,
Mhm.
look, just give me your address and I'll just bring it to you off the clock, you know. And she's like, no, 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 just eat the food and I'll reorder it. And I was like, well, I hope she got something good because I was hungry and it was good. So it was all good.
Yeah.
It worked
Nice.
out. I was like, fine, I'll pull over at the park and eat your KFC. So I did.
Oh, I forgot they have oatmeal.
Ooh, I never cared for oatmeal.
Oh yeah,
I'm a
oatmeal
I'm a
and cream
grits
of
girl.
wheat. No.
Ew, cream of wheat.
Do,
My
do, do,
cousins had
do.
a their grandma, we called her Nanny. She tried to
Mhm.
feed us that stuff all the time, and I was like, I want milk and cereal. I do
Yeah.
not. That stuff don't even look. I don't even know what that is. I was the
Mm-mm.
only one that didn't want to eat that stuff.
Mhm.
Give me a bowl of grits. One of my children, he does love the oatmeal though. He always liked it.
Okay, let's throw that in there.
I bought myself some pound cake, strawberries, and Cool Whip yesterday. Store did have that. Like for some reason, I was craving. I had these little mini pound cakes, and they were so good. And I was thinking to myself, "Damn, that would be really good with some strawberries and Cool Whip on the top."
Mhm.
And like I just had to make it happen, so I get that craving over with. You like both, but she's picky how it's made. Gotcha.
Yeah. You know what I'm really wanting?
So
A cherry pie. Nobody sells cherry pies on the side. Like
right,
McDonald's doesn't
yeah,
have them anymore.
they just do
Um.
apple pies, right?
Mhm.
Mm-hmm.
And what was it? When I was on my vacation, I did have like a cherry tart or whatever, and it was so good. I was like, oh my God,
Raspberry
it was
like
good.
that. Yeah, cherry's good. It's not like my favorite though.
Hmm. I just
Yeah,
was like, dang, I guess I need to go to the grocery store and just buy one out of the frozen dessert
right.
section or
Yeah.
whatever, because
Get
that's
you
the
a
only way I'm
milkshake.
going to get one. I
Yeah,
can't make one.
yeah. That's me. I don't. I'm not gonna make it. I'll have to go buy it out of the frozen section and
Yeah.
hope for the best. There's some pretty decent brands out there though
Yeah.
that taste pretty
What's the big name?
good.
Is it Sara Lee that
Sara Lee, because a
made
lot
really
of times
good?
I'll crave like a lemon pie. My grandma used to make homemade lemon pies with the
Hmm.
meringue on top and all that business, and I've never even attempted because I'm like, whatever. But
Right.
when I want a lemon pie, girl, that's my go-to right there.
Let me check Kroger really quick and see. Oh yeah, Marie Callender's looks like they have a good one with a
Oh
cherry
yeah,
crunch top, or yeah,
I
crunch
bought a,
top.
I feel like I've bought a couple of Marie Callender's pies, but most of the time
Hmm.
it's Sara Lee because I
And they
know
have
that.
the lattice ones too.
Oh, okay, cool. Butterfly says one of her favorites is key lime. Key lime is good,
Yeah, it is. I've just been craving cherry though for some reason.
right? It's like me with the strawberry and the pound cake. Like as soon as I finally get that out of my system, I'll be. But you know what, Butterfly? I thought that the pound cake would be good with some banana on top as well, either strawberries, banana, some sort of fruit. I'm like, it's summer. I just want to eat that kind of stuff.
I'll even take a Hostess cherry pie at this point, but yeah,
It's just anything to feel that craving.
those are hard to find too.
Yeah,
Let me check Publix. Hmm. Okay, now I'm gonna
I
just
haven't ordered a
making
food
a
order from
list.
Publix in a while, and maybe I need to do that when I go grocery shopping next week. They're closer to me than Walmart Supercenter.
Hmm.
And I don't think that I know that Winn Dixie was sold, but I don't think it's switched over to Aldi yet. Aldi, whatever the hell it's called.
Hmm.
They got one of those down further in town, but I didn't care for it.
Huh.
Oh, yes. Good morning, Joe. You do have the day off.
Oh, because Crazy
Yeah,
still needs a day to
Crazy
get
is
it
still taking
together.
that day. You should have heard that pathetic voice. She even made it worse.
Gosh.
One of those people that when they don't feel good, it's like you or I, we don't feel good. It is what it is. She's all there,
Hmm.
I don't feel good and I need to get in this wheelchair and
Oh man.
go take some darn NyQuil, honey.
Is there a clip somewhere online? I want to see this.
I actually clipped a piece last night, but I did not upload it yet.
Oh, okay.
I didn't upload it yet. I actually fell asleep. I was getting an, I was watching the, oh, something I was, something I was watching on court TV about another case that I followed a long time ago. But anyway, they were giving a show about that. But I fell asleep during the darn thing. So I didn't upload my little clip of Lori Vallow last night. But
Hmm.
um, we do have the hearing um, where that was presented yesterday. And then Joe went live last night and he had the hearing up again. But yeah, she just whines through that thing, girl, and carries on about how she don't feel good and don't want to disappoint people. Yeah, Joe,
Oh,
I got there with two. Go ahead and post them. But I watched when I got off the air yesterday. I watched that one hearing where she tried to come in all sickly.
Hillshire Farms is upping their game.
Are
I
they?
went looking for the cherry pie. I was like, oh, let me see if Target has it, right? But get this, they have a Hillshire snacking wine infused salami, cheese, and crackers,
Uh-uh.
small
Get out of
plate,
town.
like box set. Yes. It's
Because I like
wine
that's my
infused
shit right
salami. I'm like,
girl.
wait,
You
what?
just said, well, send me that link. Like what?
Hmm. This is a Target. You've got one of those near you?
Well, yeah, semi near me, but it's okay.
Okay,
It's still
let's
down there
see.
by the Walmart. I got Target and Walmart really close together, but they're still far away from me.
Just threw that in general chat.
It's my daughter's favorite place to shop is Target. She's always in the Target, usually in the Taylor Swift aisle.
They're supposed to be redoing my Walmart. And I was like, yeah, I hope so because I have abandoned Walmart for Target.
Yeah, we have that one Walmart Supercenter. I heard they're going to build one out closer to me, but make it a market, and that's fine.
Hmm.
Um, then I have my Publix and whatever they're going to do with that darn Winn Dixie.
I want
Otherwise,
them
I
to
got
go back to
town
24
stuff.
hours.
I
Walmart?
know. Yeah.
Mm,
A lot of them aren't anymore, especially if they're in a rougher area. They
mm-hmm,
started closing the ones in our town, say the ones that were in not so great areas. Those
mm-hmm.
were the ones that were closing before, overnight. They wouldn't be open 24 hours. But I think a lot of them have done that now, not 24 hours anymore.
Well, right. Ever since COVID, they all
Yeah.
stopped. And
Yeah.
then they've never, like, really brought them back?
And a lot of people like to go at night like that. It's
Mm-hmm.
not a big crowd.
Yep.
All the thing it's just you. Good morning, Vixie. Welcome in. Welcome in. Yeah, I don't venture off to the stores as often as I didn't like going to start with. It was just I had to go because that's why we had to go. We have to go because we have to go. Um, I like ordering it if I can get away with that. So much easier. But then again, if you order from stupid Walmart, they put everything in a darn bag. It's like, please bag all of my stuff. Make me come in there and do it because when I go to Walmart, I bag my own stuff. I don't want to make
Mm-hmm.
small talk with the lady at the register and hear how she doesn't like her job. I don't want to. It seemed to be like the constant state of things when you went through a checkout. Had to hear the complaints about the job or the coworkers. I'm like, I'm not.
Mm-hmm.
You're going to have that wherever you go, so shut up. So I'm that person. I'm not thinking about people losing their jobs. I'm thinking I'm going to bag my stuff the way I want it because I'm OCD and I'm out. Peace out, people. So much easier.
Yeah, I couldn't even go to Walmart anymore for curbside because they always mess up your curbside order too.
Yeah.
And then you have the worst time trying to get something corrected, you
Mm-hmm.
know? Whereas Target, they're like step for children about the orders. So
Yeah. Yeah.
curbside, yeah, never had a problem with them.
I used to go to the Target a lot because I literally lived in the neighborhood behind where Target and Publix were built, but they were literally next door to the Walmart and stuff. So I literally just 5 minutes, I had everything within my fingertips. And I always preferred going to Target if I could get away with that versus the Walmart. Walmart's just so crowded. You'll never catch me up there on a Saturday or Sunday, ever, ever. My son learned a hard lesson. I tried to warn him. He didn't believe me and took off up there on a Saturday anyway, and he came back hours later and he looked defeated. I was like,
Oh, yeah.
"You okay, baby?" He's like, "Damn."
I do understand that because, like you said, if it's a weekend, I will wait the 4 hours or however long it takes them to get a curbside order together rather than walk inside,
Oh,
or
yeah.
I'll do 2 hours or less for
Oh,
Target.
yeah. We
Yeah.
got some movement in the courtroom.
Oh, cool.
We have Bev
Three
greeting
questions. Are you
everybody.
all able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
No investigations were done.
Affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should be. Is Dr. Russell in the back there? Mr. Brennan, you can set up if you want to.
All right, I'm going to go grab fresh coffee while they're getting started.
Okay, cool.
Doctor, I'll remind you, you're still under oath. Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
This man is hell bent on saying someone helped her with her report.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with the report? What did you tell us?
I said Mr. Lessie.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you know, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
I don't. Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
Have you had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you just
please.
testified to. You want to
Yes.
see it again?
Yes.
Okay. And by the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Same advice you gave your people? Dumbass.
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
That's a sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during your
we didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the
Oh, Lord, woman.
sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
didn't.
to speak to the attorneys overnight?
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to this sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
Just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just a sequestration order.
We did. We spoke about Boston, how I love Boston, area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red
That's-
Sox or the weather. What else did you talk to Attorney Alessi about this morning, other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
And we want to know all the
Just that I
proctors.
should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he tell? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
Do you have any memory issues?
Nice.
No.
May I approach?
Yes.
You freaking may.
Transcript. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than 100, you couldn't be 100% certain?
That looks consistent.
Okay. You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes,
May I see the
of
transcript?
course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that.
Yeah, you better strike that, you heifer.
May I approach?
Yes. What page you want us to?
23.
I like to meet this dude in a freaking bar one night.
June 21st, 2024, Doctor?
June 20th.
Page 23, line 14. Will you ask the question based on everything we've discussed today? Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? And what did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you.
She's like, you ain't getting it back till I hand it back. Get him, ma'am.
When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word, or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether, to a reasonable degree of medical certainty, the injuries were from an animal attack, possibly a large dog. You agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Do you remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes.
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There is no standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source. There is no recognized community. There's no certification. There is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer-reviewed articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer-reviewed articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites? One article, one journal, one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before I approach. Can you point to one place, one, where there is a readily accepted standard in the dog bite community for identifying dog bites?
No.
And so with no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Isn't that fair to say, Dr. Russell?
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor. Regarding dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the and the articles that I read. The numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out. You sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want to get involved. I wanted to offer my my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
I would like to put up
he does?
an exhibit of Mr. O'Keefe's arm. And I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for a sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5?
Which did you call
sorry, this
4?
one,
4,
5.
5, 6, maybe.
Okay. So as we go through, identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the transcript.
Do you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails, the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Exactly.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a wound?
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
No.
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what caused this wound?
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered. Remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog oftentimes, or most times, are horseshoe-shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, you know, at the end of the paw. They come to a point. And by the way, the paws can open and close, so the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh yes, depending on the tooth, there's different shapes and sizes, absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people and you again iterated that this could be teeth or claw marks? That was your testimony last year, teeth or claw marks, right?
Your Honor, I'm going to object to the characterization of that prior proceeding.
So just prior proceeding, folks, that's all that we need.
Did you testify at that prior proceeding last summer that this could have been teeth or claw marks?
I would need to see the transcript.
May I approach?
Yes.
When you first testified on June 18th, Doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin, and you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
Dr. Russell, I'm just going to ask you to keep your voice up, okay?
Okay.
Thank you. That was your first testimony last year, yes?
Yes.
Okay. And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking if you remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes.
after your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
No.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes.
Okay. The pointy teeth, the big ones, those are called canines,
Correct.
and the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth, and even more specifically, canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to being very certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did the report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about photographs that would help you change your opinion from teeth and nails to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth. Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you testified previously that the point of entry would be here at the bottom, and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there, and the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Or you allow.
Do you remember that conversation? You said that the point of entry would be the bigger circle, pull this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that at all.
Remember that conversation
No.
we had? Okay. And so, inevitably, when you look at this part of the wound alone, have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog?
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound up
Yes.
there, closest, I agree, yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me, yep, four, same. Looking at the wound alone, you would not be able to say it came from a dog bite.
Correct.
Same for 5 and same for 6.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number 2, what caused this wound, Dr. Russell?
Number 2, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty. So when you look at this wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with the methodology and what you don't. So looking at wound number 2, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there anything about your methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these 2 scratches, they're linear, just like these are linear, aren't they?
Yes.
But you have a problem with these because if these are the canines, you see the spacing there?
Uh-huh.
This is nowhere close, is it?
I didn't say that these were caused by canines. And spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these not exact, these 2 linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Excuse me? No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new opinions. Do you have a clearer opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
No, I'm going to object to the word that was used that's been done before.
Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Can
approach?
you just hold 1 second? Could you please turn the fan off, Paul? Jurors, is it okay if we turn the fan off so we can hear better? Thank you very much, Officer DeLong.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth, weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then, sorry.
Oh, go ahead.
Are you done?
Oh. Yeah, actually, I did make another comment. What is it? So, however, what is interesting and certain is that there's an upper set and a lower set. So, this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper, and these are from lower. That's what I was referring to.
And so when you first described this wound as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believe.
And today, you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You
Yes.
were asked, what do you think? And you didn't say, well, not 100% certainty. Your claim, the first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two were caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the arm?
exactly what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, you know it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, there are many times when only the upper jaw strikes the skin.
The lower jaw is a lever, locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes and coincidentally every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top, but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, these could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But yes, I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree of medical certainty whether or not this was caused by a tooth?
Yes, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us to a reasonable degree of medical certainty whether this superficial abrasion, put that back up please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you first talked about these wounds, again, is it fair to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be
Well, do you have the
specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
Do you have the opinion today that that those were either teeth or claws?
Yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
So I'll strike the comment.
Can you tell us to a reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
Did you ever change your mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
The one near the wrist, you had testified yesterday, there's lines in what you believe to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claimed, you think different teeth other than the canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound, given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic. It bends. It depresses. So you could have two prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement between the two can be slightly different depending on the elasticity of the skin and the underlying structures.
This is not a slight difference, Dr. Russell, is it? The
I,
distances?
again,
Objection, Your Honor.
So there was a question at that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by two canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement for this one?
I think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did
measure
not.
them? Did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was inaccurate?
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper or report, notes?
That's correct.
Why would you even go through the process if you're looking at it and your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, Doctor, that the gaps between 1, 2, and 5 are dramatically different from each other, aren't they?
They are. However, I'm not saying the same exact teeth caused those marks.
When you testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis. Do you remember using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if you're-
methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with, and that forms a basis for me.
Do you really think?
I'm sorry, she needs to finish.
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent with a car collision. Did you offer that opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors,
Have you
yes.
studied that before you gave this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up
Did your
with this
people?
opinion?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
I have looked at
And when
photographs.
you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022 at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft
She
or
said
frozen?
alleged.
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there were several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at
I
the
don't.
pants?
I don't know if I looked at the pants.
When
To
you
tell
say
you
you
the
didn't
truth.
see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as
So
possible?
we'll come to side letters.
The look on her face, she's like, this dude, yeah, she's being ambushed, right? Oh, you are. Dolphin is. She's like, I was confused for a minute. Deer at the front door, sunroom. At the same time, they're surrounding you. We knew it was going to happen. They're like, you need to get out here and feed us, ma'am.
Yeah, I just open the blinds and it's just standing there looking at me.
It's that
It's
time of
still at
morning.
the front door.
Yeah, it's that time of day. It's 9:30. Well, Eastern Central anyway. Yeah, it's
Yeah,
time.
you hear
Time to
that?
get up.
Yep.
They're like, I'll go around front. You go around back.
Yeah.
We got it covered.
Oh my goodness. Tag team.
That is funny.
She's still over there.
Butterfly says she needs a picture dolphin.
Oh yeah, I recorded one yesterday. I meant to send it to her and I forgot to send it.
Yeah, remember yesterday Firefly said Pixar it didn't happen.
Yeah. Yeah. Oh yeah,
It's so
we
funny
know
that
you're in there. Totally. I was just like, really?
Mhm. They got you figured out. They know that is the best place on the block. We're never leaving. I don't blame them. They're safe right there. They don't have to forage for the food.
I'm just kind of like, oh my goodness, because the phone went off saying the back door, and then I looked, and then before I had a chance to pull it up, the front door is going off.
In a few
You know?
minutes, you're gonna have like 15 deer out in the yard. They're all like, "Our friends told us about this place."
Hmm. Yeah, no, that's cool.
That's like when my old cat drug his son home with him. I was like, "What, dude? Really?" He
Give them
tried
a
to bring
safe
his yeah.
space to hang
That
out
I'll
at.
never forget that day. I came out the front door and I heard two distinctive different cats, and I was like, "What?" And I looked back, and my cat walks around the car, and then right behind him trails a little kitten that looked just like him.
Hmm.
That cat's still here. My other cat, he wandered off again, and I know he never came back. I couldn't keep him at home to save my life. The other one will not leave the yard. The little kitty, the pole barn, I call the pole barn kitty. It just doesn't leave.
Hmm.
Just hangs out in the yard.
Here, I'll throw that in general chat. Oh, the file size is
Oh,
too big.
yeah.
Oop. Let me see. Let me figure out where else
Yeah.
I can put that.
Dolphins over there running a deer sanctuary. Butterfly.
An unofficial one, yeah.
Yeah.
That's so funny. Oh yeah, I had such a nice video. I think the video is in 8K though. Maybe that's the problem.
If you tried to upload the Discord, it only lets us do yeah.
Yeah, yeah, it's 8K. It's
Without fire,
317 megabytes.
and I've never bought Nitro for Discord.
I'm not doing it either. Yep.
Yeah, me neither. I don't have a reason to.
Let's see. Where else can I put that? Oh, I could put that on my YouTube channel.
Oh, there you go. Sure can.
Yeah, they are just funny though. The timing of animals, I swear. Are they wearing watches? Because they just know.
They know. That sun is their clock.
Hmm. Let's see. Maybe I'd have to load it from the phone.
I know I wish my bedroom window was on the opposite side of my room because then it would face out toward the fields and the woods, but mine faces the stupid highway.
Oh, yeah.
Yeah. It's like I like to go sit out in my backyard because then I can see all the woods and the field and enjoy my wildlife like I like to do. Their butterfly just dropped a link to your channel. Awesome.
I haven't even gotten it there yet. Let me
Well, we're
see.
ahead of you. We got you covered. There's the dolphin
Oh,
link, guys.
there
So
we
when she
go.
gets it all uploaded, you can go over there and take a look. Now we're going to expect some of those photos from Greece to show up over there too soon.
Let's see. Yep. Oh, I guess, yeah, a short. Let's see.
I think they would just are at sidebar butterfly. They usually take break closer to 10 or yeah, usually closer to 10 central.
Yeah, y'all will get to see my how I ruined my paint job on my car too, because it's
Oh
in there.
no.
Remember I told you I was going through the automated car wash too often.
Oh yeah, yeah.
Yeah, I've got to get it repainted, but it's uploading now.
Okay.
It's about a third of the way done.
Dr. Russell, before
You
you
got
gave your
one
opinion to
short
this
up with
jury,
14,000 views.
I know.
suggesting
Isn't
that
that crazy?
Mr. O'Keefe's
That's
wounds on his
crazy.
arm were not
Alvin and the
caused by an
Chipmunks
impact
Christmas
with a motor
doll.
vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I don't see any medical evidence that there was impact with the vehicle.
Do you know Mr. O'Keefe had other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When you considered excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same speed and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
Yes.
Another person in the same exact collision could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are the instances that you have considered where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries, correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a vehicle's involved, have you ever been involved in treating patients that received injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you
several different
Sorry, she needs to answer.
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Oh, first of all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity, no significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's body?
I couldn't tell. on
Did you
the
ask any
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear of the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Could I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that there was one shoe off, correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you
I am
came
so
to your
bored.
conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important, however, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study in the foundation of your opinion that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022. yes?
Yes,
Early morning hours.
yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having a trouble
Okay?
understanding the
It's
question.
my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes,
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
that's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes,
And you learned that her right rear taillight was broken and missing pieces, yes?
yes,
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, a car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in a certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So you, in your investigation, you did not want to know when that taillight was broken.
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked. Yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I didn't. I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear taillight is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do that?
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements? Yes. Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact or collision in this case?
Oh, are you referring to what you've asked me previously about, did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact or collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way, change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because she had, the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble.
Amen, sister.
They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, weren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Right. Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA?
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
Morning break here in just a moment. This man is so annoying, Dolphin. Yes, he is.
Oh, this is the break?
They went to sidebar for a minute, but they'll come back and say morning break, probably. That's what they usually do. The morning break will probably...
Oh, okay. Yeah, I know I said, I don't know, maybe like 40 minutes ago that he'll still be standing up here 2 hours later asking her the same questions, and so far he's almost in for an hour.
And one thing's clear, none of these experts know exactly what happened to this man. All they can do is offer their expert opinions. So just like his witnesses came out here and done, I mean, good Lord. And here he is complaining about, did they tell you to ask for reports like you did with Jennifer McCabe? That was the most report asking lady I've ever seen. Then she didn't even trust the damn reports. Golly. The jury has to be paying attention to his attitude, right, towards his own witnesses versus the defense witnesses. The defense is coming off as more likable to both sets of witnesses. The jury pays attention to that shit because I do. I hope they do. Oh, my phone went off. Sorry. My kid is in West Virginia and he's been sitting idle for 2 days. And now they're up moving around this little tiny town he's at. This kid, he calls me. He's like, it smells different. I was like, what are you talking about? He's like, Mom, I go outside and I just see giant mountains and it's really cool and it smells different and it's better. I was like, oh shit, my kid is so going to leave me for this girl in these mountains. It's coming. He's gone for a week. Okay, I was checking something. I think jury perception is going to go a long way with this case. And knowing that another trial already took place, then you know there already were major problems. And why wasn't she found guilty? The jury has to wonder that. How did the state mess up so bad? What's going on here? And I think a lot of that's being shown in the right way, I hope. Uh-oh. Okay, Dolphin, you're good. This lady with the crazy braid. I probably shouldn't talk about her crazy braids since I'm in a messy bun right now. Well, it's actually not real messy. It was pretty crazy, y'all, how the way the prosecutor decided to come into open court and on national TV and talk about the way John O'Keefe's brother-in-law passed away with his child sitting in the courtroom. Like that. What gives this prosecutor the balls to think he can walk up there and say and do whatever he damn well pleases, but nobody else can or should? Then they're the one with the integrity problem. I don't think this guy, I think he'd sell his soul to the devil to get a win. And apparently that's what he's doing. He just strikes me at this point, right? At all costs, just win. Even if it means slinging my victim's family and into the mud. We didn't need to know all that, sir. A butterfly, I'm not sure if the kids actually knew. We had always been told heart attack. That's what I'd always heard, right? I never questioned it because it made sense to me that it could have been overwhelming for him, right? Could have caused a heart attack. So I never, I don't know much about that family and never questioned them in any kind of way. But that's what we'd always heard was heart attack until he said otherwise in court. So I don't know if the kids were kept from that or not. They would have found out eventually as they got older, but as for their family to decide. I agree, Firefly. It shows, right? Like they just don't care. Talking bad about each other, pointing fingers, running around doing nefarious stuff on their phones and acting crazy and telling lies everywhere and letting stuff out of the bag when they know they shouldn't. Yeah, right. It is butterfly, especially if the kids didn't know. Who is he to come out and put that out there? What was the
Taking
point of
longer
putting that
than
out there, right?
any of us wanted to do while you're sitting
To
here.
gain
So we're
sympathy from
going
the
to
jury?
continue what we're doing, but we will give you the morning recess. So let's say about a half an hour or something, okay?
All rise for the court, please. Close your notebooks. Follow me.
Okay, did that work? You back now?
Yeah. Hmm.
Okay, cool. All right, so they're on a quick break. Um, so I'm gonna pull up a quick short that I dropped this morning. It's just a little clip on the Lori Vallow stuff so Dolphin can hear how pathetic she sounded. That way y'all don't have to watch the whole thing, the whole hearing. Let me see, did I add it here? No, let me go to my, oh wait. I saw that Seeking Justice, they always put out a like a court schedule for the day. They always put out our stream schedule and I'm on there, but she put out a court schedule for today and she says on her schedule that Lori Vallow hearing or shit jury selection will resume at 4 p.m. I don't know if that's true. I haven't heard anything about that. I know the judge tried to offer a remedy yesterday whenever she was too sick. So he wanted to know if she would allow her assistant counsel to step in and finish jury selection. But Lori wasn't having that either. She didn't want.
Oh
I
boy.
don't know if they ever decided that. Then Trina K, the prosecutors, offered a remedy. She's been good about offering remedies to every little thing Lori comes up with, to where like neither party be like the judge wanted to bring in the ones they've already like preliminary questioned, right, with their questionnaires that were mailed out. Like he could finish that part on his own and without either party present. I don't know if they officially decided to do it that way or not. So um we'll see. Okay, let me pull this up because they'll be on break about 20 minutes. Okay. That one I made on, I stole. Okay, so microdots, I'll show you that in a minute. They put something on Twitter and I just had to go clip it and make something out of it. It was so funny. Okay, so this was, let me get my screen out of the way. Okay. Is it gonna work? What's going on? Oh, there's Hank. Why is it not playing? Did I not push play? What's going on with it? You guys can't hear it either. I think I got it on mute. Hold on.
Half, where I was sitting here trying not to throw up them.
It's not factually.
Last time you said it was going to be 15 minutes, it was an hour and a half, where I was sitting here trying not to throw up on TV in front of the jurors.
Which maybe we could, all of us leave and they could come in and just speak with you.
That's fine.
I've had that happen before where none of the parties are here and the court just advises that we're unable to proceed
Your Honor,
today.
I don't know about you rescheduling this for Wednesday. It puts a lot of pressure on me to be better and ready for Wednesday, and if I'm not, I don't like to disappoint people. I don't like putting people out of their way, all the jurors and all these things, and all the pressure is on me. That's not going to help me get any better anytime soon.
What is your suggestion?
I don't know, but I'm saying if I were, so tomorrow if I'm not better and I let my team know, are you going to drag me in here like you did today with the team that came to get me? Do you know they felt so sorry for me to have to get dragged out of bed to be here?
Yeah, the answer is yes. I probably will order that you be here Wednesday. We'll take tomorrow off. Because I need to confirm how you're feeling. You because you represent yourself, no one else can waive your own appearance.
You're welcome to come over to the jail and come to my cell and see how I'm doing in there.
All right, I'll take a pass.
That's epic. I mean, so the way they had that stream going, the bottom box was Lori, and she's sitting there in a wheelchair. It's hard as heck to see her. The box above her is the prosecutor. Above her would be where the witness was, and above that box was the judge at the top. But
Oh, wow.
yeah, it was a crazy feed they put out. It was weird. But yeah, she just whined through the whole thing. She doesn't want to disappoint people. She's so sick, blah, 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 blah. So I don't know if they officially decided on a way to get that back up and running today to finish her jury selection. Because if they don't get a jury seated by Wednesday, they
Mm-hmm.
may have to do a mistrial and start over with jury selection. So that's why they're wondering if Lori is just being Lori and using her little bit of a sick. Because I do believe she sounds like she's a little sick, but that doesn't mean she's sick, right? Just enough to use it to her full advantage, maybe. That's the
Yeah,
impression
she
that I.
sounds like a whiner
Oh gosh,
too.
yes. She didn't get her way, and she don't like it. She just don't like it. So guys, let me while we got a few minutes here, microdots, like I said, put this on, noticing that Hank seemed like something interrupted him, right? So let's take a look at this. It was, let me make this a little different. There we go. Okay.
It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is most conscientious, dedicated, admired state police officers in Massachusetts.
That's just epic. Look, he's all intimidated by
After having
Karen
his
Reed.
name attempted to be sullied all over social media, attacking his integrity and his name is not factually viable. It will be distracting, confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is most conscientious, dedicated, admired.
So every time that we notice him, guys, if we notice he stumbles for a moment and gets quiet, we can take it to the bank that it's probably because Karen Reed's looking at him, intimidating him.
Oh boy.
Oh yeah, she's so intimidating, right? I'm like,
Mm.
these court things are so epic lately. I mean, I know I was watching, I forget whose trial it was. It was a while back, and one of the attorneys got up and got salty, and somebody in the chat was like, "Oh my God, they're allowed to speak that way in court." It was like, yeah, they are. They're allowed to say and do a lot that you might take you back for a moment. I've seen people do that lately. They're like, "Oh goodness." I like it when the attorneys get all spicy in there. Some are just ignorant, but some are, it's worth watching. These witnesses get all crazy and sideways. I couldn't imagine, I don't know. It'd be such a weird place to be in, to be a witness in a truly criminal case. What if you accidentally witness something,
Mm-hmm.
the next thing you know, you're all up in the middle of a court thing and didn't even want to be a part of it.
I know one thing. I would have something to say if I were on the witness stand and the attorney was talking to me a certain kind of
Mm,
way.
me too.
I mean,
It would
heck,
be.
because if the lawyer for the other side isn't going to speak up for me, I damn sure am going to speak up for myself.
Yeah, Bev can just get mad at me all she wants, right? I'm just a
Mm-hmm.
witness, but I'm not gonna take this bullshit, right?
Yeah.
We're not having it. I don't,
Mm-hmm.
yeah, it's hard to sit there and take that. Um, from either side, and it just in this particular case, we see that this the prosecution getting sideways with everybody,
Mm-hmm.
like over and over. It is just so weird how he thinks that he's making points with the jury when I feel like you're not. But then again, I could be dead wrong about how this jury is perceiving
Yeah, I
This.
mean, an hour-long quibble about, dog teeth, canine teeth, or
Yeah,
nails, dog nails is like, where is that really getting you? Because they both still come from a dog, so, and not a
yeah.
tail light. So where
Reasonable
is this
doubt was
exactly
yeah.
getting you? You
She
know?
came in and did her job and established reasonable doubt, right? She cannot say definitively that that's dog bites. That's not her job. It's not the other two. It's just not either one of their jobs definitively, because nobody can say that, obviously, or we wouldn't be sitting here wondering. Um, they can both come out and offer their opinions, and then it's up to the jury to decide which one held more weight.
Hmm.
And her explanation was way better than Mr. Paint Experiment guy,
Oh, yeah.
you know.
But
But
and then he's going to try and challenge her on motor vehicle accidents. I was like,
yeah,
you do realize she's an ER, doctor in like one of the busiest ERs in the U.S.
right.
For
On
over what,
purpose,
30
she went there.
years.
Yeah, she said she went there on purpose because of the level of activity that happens there. And if you want to be really good at your particular practice, you want to go where the action's at. It makes you better. I totally get it. But yeah, she's seen multiple injuries and wounds and different things, car accident victims, dog bite victims, all
Hmm.
you name it, she has seen it. And
I
he's
mean,
up
just think the chances that she's seen way more car accident victims than dog
there.
bite victims.
Exactly. And I think a lot of the experts are a little baffled at the lack of lower leg injuries, right? They can sit there
Hmm.
and say that the prosecution side can try to justify that all they want to, but in our rational minds, we're thinking, there needs to be a little more damage to those legs.
That's what I'm saying. A 6,000 pound car, like,
Hmm.
barreling at him backwards. Come on.
Sorry, I had pulled the feed back up and it's still on recess, but they're showing old stuff.
Oh, okay.
Old, on a Law and Crime, they're showing old testimony for some reason. They don't usually do that, but they do have the little box up that says they're still on recess. And looks like, hang on a second, because it looks like NBC is showing the same thing. Let me pull the screen up. So,
With regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge
yeah, it was a
issues
while.
that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Ooh, he was hot.
Yeah, this is going on outside the jury's presence, or
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So
All right.
That was from the other day, wasn't it?
Isn't that what he's wearing today?
I thought so. It looked like it to me. That's what I was trying to figure out. Hold on, we're going to back up and see if we're...
Case, he has introduced it.
Oh,
You would often
yeah.
find
Okay, let's
It
go
was
back.
important.
Wrongly.
Okay, so this is the beginning of it. They're going to come back from the sidebar there, and I guess they let the jury go.
Oh, I went
On
way
break.
back. There's a burgundy tie with white polka dots on. That's what he
Well,
has
see,
on
I'm
today.
just... Okay, so he did...
from a clip.
Oh, shit.
See
Show
injury
him.
with several.
He said he has on a what, Dolphin? I'm sorry.
Again, there were
Okay, he's got on a polka dot tie. You're right.
Yeah,
Okay.
burgundy tie, white polka dots today.
Let's be.
Yep. Okay. So let's do this. We'll start right here. And I'll pull the feed back up on the side as well. She did say she'd give them a half an hour. Okay, they're back at 12 noon according to the Law and Crime current feed. So this went on when they dismissed the jury for morning break. Butterfly, thank you for that update on Lady Bird. Appreciate that. I tagged Joe as well. Okay, here we go.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made, that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal, Dr. Crosby, who would talk about the absence of supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial. So in conclusion, Your Honor, because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled, under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Okay, thank you. Mr. Brennan.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear, superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her as proposed by the defense about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions, about the role that the absence of DNA played. Also, I expect to ask her about her attempt to diminish or demean the DNA evidence, because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank you,
Mr.
Your Honor.
Johnson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie, that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
May I have 30 seconds?
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour. So
All right.
Okay. Well, what do y'all think Bev's gonna do?
Oh, she's not gonna do anything. She's definitely on the Commonwealth side.
Yeah, she's gonna come up with something. She's gonna come up with something. My God. Let me get the feed pulled back up. They had a half hour, so I have to. Okay. Okay, goodness gracious. Let's see. Oh. Wow. There's been a local missing case. There's two. And this girl's sister has been relentless on her social media campaign to help find her sister. And there's people alive that probably did this. And man, she's putting them on blast. I reached out to her once because she does have a YouTube channel and a Facebook page for her sister. It's called Missing Child Danielle Bell. And her sister Bonnie has been just going hard, especially locally. There's been a lot of bad stuff in that investigation. I got to get her on. I got to look at this stuff in a minute. I'll get totally distracted. Hey, Motion to Scream. You are amazing. Welcome in. It's crazy stuff, isn't it? Oh, it is so crazy. And you did a jam up job over the weekend over there at Camp Shorty. Just want to give you a shout out for that. You did great. I need to save this Facebook post before I forget that I need to look at this. Let's see if it'll work this way. Aha. Dropped it into my virtual office so I don't forget about it later. Now I have to remember to go look later. Oh my gosh. Oh, you're welcome. You did a fantastic job over there helping Miss Shorty out. I know she appreciates it. And it was fun to go hang out on Kick for the first time like we were able to do and watch the Body in the Snow special together. That was really cool. I may have questions for you guys later if I decide to start running some stuff on Kick, because it is fun, especially when you don't have to worry about getting thrown off YouTube for what you're showing. If there's something out we all want to watch. Yeah, Butterfly, it looks like we got to get a new show together for another Lady Bird Lake update. That's something that Joe and I and Butterfly work on when a new case pops up over there, and apparently one has popped up again. And Butterfly, I noticed on the map it's very close to the same location where other bodies are turning up. But I got to deep dive that map in a little while. Yeah, it is a blast on Kick. We've been over there with Publicly Buzzed hanging out and stuff like that. So it was great to see her join the platform and now get that going. It was a lot of fun. Discord's cool for stuff like that, but if you don't have like an open Discord, then everybody can't join in. So Kick is a cool platform. Used to do a lot of stuff on Twitch back with the NFT days, but I haven't messed around on Twitch in a long time. You can go over there and play all kinds of cool games as a community together. It's a lot of stuff you can do on there. Maybe I should check that out. I still have my old Twitch account. Yeah, link that press conference. It's going to be the same standard press conference, Butterfly, right? She's going to be reading from her little notepad with the same standard, nothing to see here. They fell into the water accidentally. So dangerous down there. I wouldn't walk near that water's edge. Because according to the authorities down there, you could fall in at any given time. And they'll claim you were trying to stay warm to do so. Like, make that make sense. Usually you build a fire to stay warm, not fall into the water in the middle of winter. Yeah. Crazy stuff. So I've checked the docket as well on Stearns this morning and on what's his name, Koberger. Nothing new on either one of them. I cannot figure out why the judge hasn't ruled in the Stearns case on those damn warrants yet. That's bugging me. Like, why do you need so long to make a decision on that? Was it not so cut and dry after all? I need to know something. I wonder why it is taking that dude so long. Oh, did you put it in the chat channel? Let's see. Oh, got it. Now, is this the same, the Twitter post, is that the same as the one from the news post? Same, because the news post kind of showed a map, didn't they? Yeah. Puts it right over there across the highway from Cesar Chavez. And we know there were several bodies found along there. This is on the bike trail, the Ann and Roy Butler bike trail. And the article says that. And then the news clip, the last thing you have, the Twitter post, is that the same incident? Because it doesn't show. Okay. Cool. Okay, I see separate. Gotcha. Either Lake Austin or Colorado. They won't say which one? Holy cow. Oh, that post tells you where his truck was found and everything, Butterfly. Okay, See, I'll get into a deep dive in a second and forget I'm live streaming a trial. I'll be gone down into Lady Bird Lake. Lord, we still got to finish our map as well. I haven't had those notes out in a hot minute. Yeah, Kick is similar to Twitch, wasn't it, Firefly? I know we used to go into the Twitch all the time and do streams there, and we could just sit and play all kinds of. I used to run those games in there, and God, it's been so long since I went and done that. I need to look into it again. There was this really fun marble game. It was just mindless bullshit, but it was fun. Yeah, Twitch was first off, it was more like a gaming platform, right? That's used for all kind of stuff now, including grub truck feeds. I joined the Facebook page Butterfly. Well, I requested to join. I I was in one, but I don't go on Facebook very often. Like it's rare unless I'm looking for some information. So I thought that I was in that one, but apparently I was not, but I requested to join. Mm, Lord. Yeah, that's what I thought it was Butterfly who went to like a post his dad made. His dad was saying about talking about the search. I guess that was before they found him. What did hold on, Joe, I'm checking. Mm, oh, thank you, Joe. He just sent a link over with Lori's trial, the one we watched the clip of, or trial, shit, hearing, whatever the heck it was. We watched a clip of that earlier. Hey, Joe, if you're listening, go check out the Lady Bird Lake channel in the Discord. There's some activity, man. Might need to send you back down there, body cam and all, this time. All right, thank you, Motion to Scream. What the fuck, granted. I just love saying that name. I had to say it. I had to say the whole thing out loud. Don't work too hard, hun. Try not to. May have to come back on tonight and do a show. There's a couple of things I need to get caught up on, and I'm just like, lately I have not been doing much outside of these trials. I gotta get my flow. I don't know. I gotta get my flow going. Something. Dive off into some maps and stuff. That's probably what it is. I'm just bored. I get bored. Wait a minute. Okay. Hmm.
Okay, I'm back. I had to go feed the dog.
Oh, you're good.
I just realized her little automatic feeder had sent me a message and I didn't see it. It was out of food. I was like, oops. That and the vet called. She has to be dropped off tomorrow and she can't eat anything after midnight tonight.
Uh-oh. She having something done?
Teeth cleaning.
Oh, okay.
And just a comprehensive checkup. They should start putting timers up for these breaks and whatnot. Or we should. How
Oh,
much
I'm got
longer do we have?
about 10 more minutes, but I got the stream pulled up on the side.
Mm-hmm.
Yeah, they're still on break. It says back on the screen, it says courts on morning recess back at 12 p.m. Eastern.
Oh, 12? Okay, cool.
Yeah. Because she gave them 30 minutes after she got through hearing their arguments a few minutes ago.
Mm-hmm.
They're coming back. Somebody's coming back. They're unmuted. I got my big cup in my way and I couldn't see. Okay.
No, Bev.
Oh, Bev. What you gonna do, lady?
All right, so the motion for mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Nor I did not address sidebar the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could you do that outside the presence of the jury so that I don't ask the questions in front of the jury?
Oh, yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
I'll work around it.
Your Honor, I would object to being done outside the jury. That it should be done like I've had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants, are you sure, Mr. Alessi?
Oh, I'm sorry. Let me confer with my. Yeah. Okay. I am going to. Yes, Your Honor. We are going to.
Oh, dear.
Thank you, Your Honor.
Okay.
They're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is the lunch? Are the lunches here? Probably not. Okay. Are they still over there? How long they are?
Did you start yet, or can you turn?
I just, if they're downstairs on their way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, I'll be subject to whatever Your Honor has. Based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35, to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
No, I don't think they made it downstairs.
All right, we'll do this now.
Be quick.
Okay?
Dr. Russell, during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with a dog bite?
Yes.
Did you disregard it or agree with it?
I disregard, I disagree with his assessment.
Thank you. So I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that could do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Leslie?
Thank you, Your Honor. My response is this. I'll give two quick examples. Dr. Welcher, Trooper Paul, Dr. Squirty Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Squirty Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not. For the reasons stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay.
Well,
All right, bring the, thank you, Hunter. An objection. Where are we? Is it in evidence now?
It's not yet. It will be.
Okay.
You're not just say it in evidence.
The DNA. It's not, right?
It is not.
Okay.
Is there a question?
Yeah. Yes, it's open. I denied the motion and allowed the line of inquiry.
the session. You may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was.
Oh,
some
that one. Yes.
Remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with a car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body breaks, do you have any studies about the frequency or the likelihood of lower body breaks in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body breaks?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body breaks?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes.
And that's considered oftentimes very important trace evidence.
Yes.
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
Yes.
You've heard of UC Davis, haven't you?
Yes. In reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there were some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion?
Objection, Your Honor.
And so you're aware that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes.
UC Davis, do you understand they specialize in dog DNA?
Animal DNA, I believe.
And you also know, in giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes.
In fact, what was found was pig DNA,
That's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you
Dog treats,
saw the
maybe?
information, after you claimed there is a dog, Kubik John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes.
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
Yes.
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. Can I ask it differently?
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
no.
I'm sorry. You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, and you wonder why, and you want to know, was the test done correctly, you know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scortabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong
No, she can't.
with that DNA process, can you?
All of yours.
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle.
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please? Dr. Russell, this is a photograph.
Okay.
Tiny desk guy looks a little tired today.
I don't blame him.
He's like, man, this is taking forever.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
I don't believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying to a reasonable degree of medical certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Okay.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right. And if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolk, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16-inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions, so these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit, well, anatomically a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies, and as part of your answer, do you recall that discussion with Mr. Brennan?
Yes.
Do those, are those studies peer-reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. DeMunick, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties
So
of the authors.
I'm sorry to interrupt you, Dr. Russell.
I'm
Have you
sorry.
finished?
The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q.
All right.
And I'll start with P, 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 if I could, please. Thank you, Madam Court Reporter. May I present PPP to the, thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. DeMunick?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, Dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxillar is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite, in which the dog can lock onto his prey. The tremendous force of the bite, muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay.
Sure. 298. If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. and they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the morphology of dog bite injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay. So we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow, and so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any? Is textiles mean clothing?
Yes, and I thought you meant in this
decedent-
article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt or sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I don't want to keep
on reading.
keep reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
Yes. So as to the form, Mr. Lessing.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Objection. Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypothesis was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like me to give an example, like chest pain or?
Well, I'd like to
pain?
give you an example of what you used here in this case as the application of that.
Well, okay. So I'm just describing the overall process because if you came to a diagnosis and narrowed in on it, and never considered any other information, sometimes your diagnosis is going to be wrong. And so you have to allow for other information. And so I did that in this case. You know, I examined the circumstances, examined the wounds photographically, and came up with my impression. But I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
Not again. I'll switch feeds. Hold on. That's bullshit.
You recall also mentioning that sometimes these patients engage in self-blame.
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
Goodness. I don't even know if I know what to say at this point. Yeah, she's not given us any reason to question her credibility. And every time they got a question, she's got an answer. And, you know, she's a very well educated doctor, seen a lot of things in her lifetime. So she's cast enough reasonable doubt in my mind. And that's her whole point, because nobody can say definitively what happened. It's all about getting the doubt in there that it was caused by a vehicle and that it's a real possibility it was a dog, right? Yeah, he's doing his usual tactics at the moment, wasting our time, killing our brain cells. Oh my gosh. These people put funny stuff out on the Twitter, make me laugh, making jokes. What did that say? Let's see. So I wonder if they'll wrap her up by lunch. They've only got a few more minutes. They're probably going to come back from this and say we're going to go to lunch. Oh yeah, they've been putting her through the ringer, making her go through it and through it and through it. I think the jury clearly gets it by now. If they don't, I Yeah, the defense is up right now, Butterfly, talking to her. She's explained everything they've asked of her so far, you know? It all makes sense. It's not cluttered and, paint experiment guy over there. And it's funny how he wants to poke holes at, well, did you review pictures and this and that? Well, did you listen to your own witnesses' testimony? How they reviewed photos and did this and that? Same thing, buddy. Same thing. It's only okay if you do it, though, right? Like a lot of people out there who live by that law. It's okay for me to do it, but you better darn well better not. Please. Taylor Lori Vallow is not the only one getting wheeled into court in wheelchairs right now. It looks like Miss Taylor Shabusiness, she got herself one as well. But they got her strapped down to that bitch. I mean, did she have court this morning? They do got her all the way strapped in. Holy cow. None of that. You are not going to attack nobody today, Miss Shabusiness. Lori hollers about her rack belt one more time. We're going to show her a picture of this lady's get up. She blew the camera a kiss on top of that. Wow. Let's see. What's that lady still doing in court? That business chick. I don't even know. I don't follow her case. I don't. I thought that lady was like gone down to prison. I don't know what's going on over there. I know she's a nut. She attacks everybody in the courtroom constantly. Wasn't it last time she was in court? She jumped over and attacked the attorney. Just wailed on him for a minute. They fixed her right on up. Yeah, Butterfly, that's what she reminds me of. I'll put that's what it reminds me of already. Oh, I got the hiccups. Okay, look at the general chat. Please get on their post. All right. If I knew they weren't gonna come back, I'd pull it up on the Twitter and show you guys, but I'll have to wait. We know we've seen more than just her jump up and attack people in court. It's so crazy. Surprised she hasn't tried to escape. Maybe she thought she could if she attacked somebody in the courtroom and caused a big distraction, she could run out the door. She went wild a few months back. I think she might have been born a wild one.
May I have a moment, Your Honor?
Yes.
Thank you.
I'm surprised they didn't scream at lunch for lunch already.
Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this case? Do you recall that discussion?
Yes.
And have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here, what is the likelihood of there being any fracture to any bone?
Objection.
Sustained in that form.
Do you have an opinion, based upon a reasonable degree of medical certainty, as to whether there would be any fracture to any bone?
I believe that there was a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe,
Yes,
and you've reviewed the file, the medical records files, correct?
yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scorbello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scorbello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her? Or lunch?
All right, jurors, I'm going to send you out for lunch, okay? We'll see you at 2 o'clock. Yes, come on up.
Back to the court, please.
Okay, so they're going to go to lunch as well. Let me mute that out before they pop in there and scare me with something. Hold on 1 second. Wish they would just let them finish up with her being so darn picky about what things are asked and how. Sometimes both sides spend a little too much time with these witnesses, going over the same thing over and over. But she sent her parents out of the courtroom for. Interesting. Send them on down there to get ready for lunch. Yeah, they've had her on the stand back and forth. You know, the defense had her, the prosecution had her, the defense, and then they're back. They're just back and forth all morning with her. There's not a whole lot left that I need to glean from any of this. The jurors should be there as well. We've heard the back and forth for a while. Well, since we got here this morning. And honestly, it's what we expected. We expect both sides, both experts, to have different opinions. Now it's up to the jury to decide which opinion they feel's got more legitimacy behind it, right? That's what it comes to. And you take it, if they have doubts about this busted tail light and they have doubts about other things, this adds more to that doubt. reasonable doubt's been established. And that's literally all the defense has to do. I still want to see them bring on some spicy, certain people inside that house, though, that I still want to hear from, or more from, I should say. Yeah, that's her whole point of being there, Rachel, right? Is to testify to those injuries. Otherwise, we don't even need her in the courtroom otherwise. So, yeah. The judges allowed pretty good questioning of her. I mean, she's not really um, stopped at the defense, and and especially when they were rebutting what Hank's up there trying to do. I don't know if Joe's still in the chat or not. He posted a new document on Twitter from Lori's case. She had already wanted, a new trial claiming Juror 15 fiasco. And I knew they had to launch an investigation right away. That's not something you can play around with or push to the side or pretend it didn't happen or maybe it did or didn't, we'll never know kind of thing. You have to get to the bottom of it. So it was no surprise, especially once the court notified Lori Vallow and her uh, little attorneys there that are helping her out. It was obvious there was an investigation launched, but apparently there was, and the prosecution did speak with Juror 15 and got a sworn signed affidavit from him stating he did not know of things prior to going into the deliberation room. So, it's like I expected there to be an investigation. If there wasn't, then that's a problem. The thing about a witness like this, not only can she attest to, I believe those are dog pattern bites wounds, but I can also tell you I've seen many car victims as well, and it's not that. So yeah, she can make a better determination, right, than the other witnesses that the prosecution tried to present. Try a little harder. Yeah, they're clearing the room now. Bev is taking her mint green cup of vodka and orange juice, and she's going for a top up. I don't know. We should do a poll. What do y'all think's in Bev's cup? We got water. They drink unsweet tea, I think. It's just so unnatural. No, they gone to lunch. They had a small sidebar, and then they were going to lunch. So we are officially on lunch break. I'm going to, let me see. Let me get all my stuff together here. Let me get it together. Okay. Oh, Jesse. Okay, guys, let's see. This last night, let me see, when was it? Well, it says 15 hours ago. Oh, it's just, it's the full court clip from Little Miss Testy on the witness stand. Let's call her that. Microdots had dropped. I guess it's just her whole testimony of her being a little combative. You think vodka too? I don't know why it was my first go to with her. That's what Karen likes too. It's probably a thing. Hell, that'd be my first go to. If I'm being honest, I can drink some vodka and orange juice on the beach as long as it's nice and cold. and I don't have too many, then I'd stumble. I'd fall into the water then, butterfly. That's how it happens. Folks just don't fall into the water without assistance, do they? My assistance would be the vodka. Well, apparently, if you live around Lady Bird Lake, you will fall into the water just by looking at it, so don't go down there. I am muted. I'm sorry, guys. I was pulling something out of Discord to look at, and I forgot that I was muted. So Joy's thinking she's got gin. That's a good suggestion as well. Vodka, gin, or water? What do you guys think's in the cup? Or some damn unsweet tea? It's unnatural. I'm back now. Can you hear me now, guys? My chat is slower on Restream than it is if I got it pulled up. Yeah, you can hear me now? Okay, cool. All right, I'm back. Okay, so I was pulling up this article out of Discord, like I was saying. All right, let me share the screen with you guys and we'll read it. I gotta make that. Hang on, I gotta switch all this around so I can see it good. Okay, now you guys can see it. So, Firefly says vodka with a splash of crystal light, right? That sounds like something Bev would do. I can see that happening. So we're all thinking she likes the light, the light whiskey, no dark for her. She's not from the South. She's not throwing that shit in her coffee. She's like, no. Okay. This was just from May 3rd, updated May 4th. It was just okay. So get this out of the way. All right. Austin, Texas. The Austin Police Department's dive team has located the body of a person who went missing in Lady Bird Lake on Saturday evening. According to Austin Travis County EMS, officials responded to the scene shortly after 6 p.m. after receiving calls reporting an adult who went underwater near Interstate 35 and didn't resurface. So people saw this guy, Butterfly, go under. What did they see before that? Was there any distress? The Austin Fire Department said the person was described as a struggling paddleboarder without a life vest in the water. Around 6:45, the rescue had transitioned to recovery effort. Search efforts resumed again on Sunday morning. The dive team located the person's body at 12:35 on Sunday. Well, that's the first one that they've matched to a paddleboard accident, Butterfly. We know that they're all over the lake. We know that for a fact. But that's the first one. What is it? What in the world? That's the first one they've connected to a paddleboard accident. Vodka and gummies. Yeah, she'd be better off if she had just straight gummies. It's that alcohol that messes up your brain. Matt McCabe drink last trial. Well, we know Higgins likes his damn Irish whiskey. If you don't have any, Higgins is not coming to your party. Like, bye now. Bye with your Irish whiskey. The 17, yeah, so that's the one whose dad links to the article where he was found. Okay, let me look at that one. Okay. So that from the Instagram post, that's the same thing from the other post. Hold on. I gotta decipher which ones of these are which. Okay. Breaking, police in Austin currently trying to recover a missing 17-year-old from Lady Bird Lake. The team went missing when he was paddleboarding. Okay, that's the guy that we were just talking about then. Okay. The paddleboarder. And this one was a different one. Let's see. Are they all going to talk about the same one, though? That's what I don't know. Oh, yeah, that's again goes to the dad, right? Let me see. Let me read this, guys, and make sure I got the right one. Okay, when you send them to me, let me know which one's which. Hang on, I got to get this out of my way because I can't hardly mess. It's so hard to mess with Discord when I got this screen. I don't know why it's just Discord. It's crazy. I got to close that because it makes it too big. 3 different people. That because yeah, when I look at it in hang on, let me do it from my phone. It's so much easier. Let me get out of this on the computer. I don't know why it's different, but it is. Okay. And then I can do it this way. So the 17-year-old is not the same kid from the father's post. That's a different one because I don't, Instagram post, that guy, I don't have it turned up where I can hear him talking. Let's see. Let me go up to this one. There we go. This starts it. Yeah, each article I pull up refers to the paddle border. I don't know what's going on with that. Like, okay, so Jeff Moats is not the paddle border, right? Because this is the guy that they don't know if was in the Colorado River or the other. And that's when his dad was given the location of his truck. They searched launch point is now Emma Long Metropolitan Park. That was on Thursday of May 29th. His truck was towed from the park west of Loop 360 in Austin. If you're within 60 miles of Austin, drive through a local park, trailhead, or state. And apparently they found his truck. He was 23 years old. But he's not found near. They got a map up of where he was last located. I'll have to look into those more because they're and add them on. Look at the map, make sure I got their names correct too, and add them to the list over there, and see what we can figure out with that. I'll have to go to their Austin Police Department Twitter page as well. Yeah, I don't. There's so many coming in right now. I don't know which ones are which when I'm trying to do it on the fly. Oh, my friend. Okay. Sorry, my dog was barking. I don't know what she was going off on this time. Let me go and look at the Twitter. Ah, okay. So what I have pulled up is from the Austin Police Department on their Twitter page. Okay. Let's see what this says. So this is a media briefing. This was posted 2 hours ago, and they're quoting something from 3 hours ago, which is an hour before that. So media briefing will be at 10:35 a.m. in the parking lot of the Austin Parks and Recreation Department in the 200 block of South Lamar, which is down there where a lot of people went missing, near the hike and bike trail. Austin police detectives are responding to reports of a deceased person in the water near the lake, near a block of South Lamar. The trail is blocked off in the area where Barton Springs enters Lady Bird Lake. PIO is en route. Media briefing, time and location to be determined. So they haven't put anything out yet. Somebody asked, can we watch? And nobody replied. So I don't guess they've held the press conference yet, or it would be on here to talk about it. I'm just curious if we're going to get another cop with a little note in their hand reading what they've read, all the other incidents. It's crazy. There were 2 paddle boarders. So all of a sudden now they're saying they're paddle boarders. Interesting. We've got one set of well, we only know that with one of them there's witnesses said they saw it. So right, Lamar is 3/4 of a mile upstream from Congress, so it's a little bit west of where most of them were found. Yeah. Because one of the ones that I looked at a few minutes ago had a map attached, Joe, and I could see right then on the map there were other locations we had pointed out. They had the presser. You watched most of it. The same guy from the last one we watched. Oh, where'd they have the presser on their Facebook? Because I don't think they had it on their Twitter. I think I have Facebook on the PC. I don't mess around with the Facebook much. Unless I have to go look at a press conference or something on there. Which they do a lot. Oh. Sorry, my phone went off as I was waiting on a message from my friend's kids, and it just freaked me out. Sorry, 1 second. Okay. A lot of times when they do the updates like this for Rex Hurman, they'll do them on the Instagram page. Okay, I'm on their page, but they have, let's see, go back. Yeah, a lot of times they do. They're all on Facebook anymore. And now Instagram as well. It's crazy. Okay. What in the world is going on here? Okay, I think you would think they would put it on all their social medias, right? And they would link them or whatever. So let's see. It's not that one. It's this one right here. Okay. Do I still have the screen pulled up? No. All right, let me pull the screen up. Found it. All right, this is their Facebook post on it. Let's see.
All right, Corporal Jose Mendez, that's JOSEMENDEZ with the Austin Police Department Public Information Office. So early this morning, we did have a male individual recovered from the water here on Lady Bird Lake. Our hearts go out to the victim's family, friends, and all those that will be affected by this tragedy. This is a tragic and unfortunate situation, and we're trying to figure out why this took place and what happened. Safety here in Austin will continue to be our number one priority, and we will do whatever we can to figure out why this happened and what we can do from preventing anything like this from happening again. I will say this past Sunday at approximately 7 p.m., we did have a family paddleboarding here on Lady Bird Lake. At some point during their paddleboarding session, one of the individuals went missing from their family. That family reported this incident to us. APD, EMS, AFD all responded to the scene here, and unfortunately their search yielded negative results. They could not find the individual at the time that it was reported. Today, at around 7 a.m. this morning, we did have a caller call 911 stating they observed a body floating in the water of Lady Bird Lake here near Riverside and Lamar, here at the Butler Hike and Bike Trail. Right now we are trying to determine if the individual that we have this morning is the same individual that went missing Sunday evening. Again, this is a tragic and unfortunate situation, and we grieve with the family at this moment. We're trying to make positive identification on this individual that we have, so that we can report back to the family if that's the case. Right now, we have our missing persons unit on scene. We have our medical examiner's office. We have our crime scene specialists. And they were trying to determine what took place. When APD responded this morning, they were able to successfully recover the individual from the lake. And like I said, we're trying to go through the notification process, the identification process, and we'll wait on the medical examiner's office to kind of give us their ultimate determination. Right now, based on preliminary information, there is no foul play suspected. There is no trauma to the body, and the individual that was recovered here today was wearing the same clothes as the individual that was recovered Sunday evening. We want to thank our community for coming forward and reporting this to us this morning, so that the investigation can continue from this point forward. I'll take any questions that you might have at this time.
You were saying the individual that was found today was wearing the same clothes. Say that again.
Yeah, so the individual that we have today is wearing the same clothes as the person that was reported missing Sunday evening. But again, we're going to wait to make that positive identification, and that's so that we can notify the family in the event that this person is the same person that went missing Sunday evening.
Did you say a man? Do we know if it's a child, a man, adult?
I'm being told it's a black male, possibly in his teens.
Late teens?
In his teens.
In teens.
Yeah, in his teens.
Who called 911? Do you know?
Today it was just a citizen that was paddleboarding. Another paddleboarder was here out on Lady Bird Lake and notified us that it appeared that an individual was deceased and floating on Lady Bird Lake.
You said that this person was reported missing on Sunday. Was the search still active yesterday?
Yeah, so we've been utilizing the resources that we have, our lake patrol unit, and all the equipment that we have that typically takes place when an event like this happens. Like I said, we were notified Sunday. That was around 7 p.m. So, nighttime and the time of day played a factor. So that transitioned into a recovery stage the following day. And finally, here we are today. A witness reported seeing the body, and we were able to successfully recover that body from Lady Bird Lake.
How many bodies have been found in the lake this year?
I don't have those numbers available right now. Anybody else? Thank you.
Well, the fact that this one was found in the same clothing described by the family of the missing paddleboarder, I feel like this is probably just what that is.
Mm-hmm.
I don't have a reason to. And I've seen their sketchy press conferences in the past and how they will sidestep things, and how most of these people that have gone missing or fell into the water are mostly homeless. A couple of them have not been. It's a whole deep dive, and we've went down this with past shows. So we always keep an eye when a new body turns up in Ladybird Lake. But this one sounds like I'm more inclined to believe it because of the fact there's people reporting it. Yeah, they're going to give you the same word salad, but what my takeaway from their word salad aside, because I've come to expect it, this one had family members reporting a missing paddle boarder, and the person was found wearing the same clothes that the family described the missing man was wearing. So this one sounds logical. Yeah, I get it. I'm surprised there wasn't more paddle boarders gone missing. That's why I pointed that out earlier. This lake is full of paddle boarders, and now all of a sudden, instead of just slipping and falling into the water, we've got now they're paddle boarders. But if I'm going to be logical, because I can't just. There's witnesses, there's family members describing it, so I'm just going to leave it be for now. Joe, he said the person recovered from the lake was wearing the same clothes as the paddleboarder that was reported missing. But they weren't going to assume they're the same person until they notify the next of kin and get them in there to verify that's the person. So if he hadn't have said that, I'd be at a different place. Yeah, we have canoeing. We have a famous place here to go canoeing, and you'd be surprised people won't, and they get drunk and canoe and tube down this river all summer long, and we're going to hear of some accidents this summer, trust me. Fools get out there drinking, they're not trying to be safe. 10 foot tall and bulletproof. Yeah, I pay if like I can't let that one suck my brain cells, because if the family hadn't said, here's what our paddle boarder was wearing, and this guy pulled out, they were wearing the same thing apparently. So then I'll just reserve my brain cells for other rabbit holes. Then that's what I'll tell them. Okay, to y'all, until a family tells me otherwise, I got to roll with that one, right? It's just how it be sometimes. So, Joe, have you heard anything about Lori having jury selection resume at 4 p.m.? Let me find, where did that go? I believe that is what. Let me take a look. I don't want to misquote it. Okay, that must have been yesterday's. Never mind. I think I did misread it. A lot of Rachel. With this one, is pretty easy. There's so many quote unquote accidents around there. They're not all accidents. They're blowing smoke up our behinds. That's why we're watching it closely. But this particular case seems different out of all the ones we've looked at. Yeah, I know. I just saw that Seeking Justice had a thing, and I think it was, let's see, oh, it was, well, it says today actually. It says 6/3. She always puts out her court docket schedule, right? And on the last one, her last entry is Lori Vallow's selection today at 4 p.m. And I didn't know if they had to come to a remedy or not, or if they're just going to wait and go back at it Wednesday morning. Because the judge had talked about finishing up part of that without them present. And Trina offered that as a remedy as well, but I don't think they made a decision finally. I knew they were coming back Wednesday morning. I knew that part. It threw me off when I saw this morning. I was like, maybe the judge did decide to go ahead and go forward with some of that as planned. I don't know. The 4 p.m. part threw me off as well. So I didn't know if you had heard anything different. Okay, let's see. Yeah, well, they should have thought about that before they seated that person as a juror, right? I don't know, Joe. Information comes so fast. Who knows? Sometimes it might be a accident, right? Seeking Justice is actually a very good community. I like their Discord. I like her information. I love her court schedule docket. That's how I can keep up with some of the other cases I follow that I don't talk about live a lot. I can always get the information right there. Since I'm not following Lori so deep and hard every day, I could go find out, but I don't study her like that. I don't like that we can't just go see the court documents either. I have a problem with that. I don't like any state that just don't give up the documents for like they're supposed to. I don't care what their excuse is. Jury selection is usually so damn boring. It's like that. It's just the same standard questions. You're not going to get like a thunderbolting moment. It's fun to watch them dismiss jurors for their different actions and what their different reasons and all the things that they can dismiss them on. They have some pretty crazy answers at times. Standard formalities, my goodness. Yeah, they haven't. They haven't started anything yet. That case has gone to shit. Can't control their client. Can't control the defendant / attorney Lori with the capital R, who's out there trying to buy time. And like I said, the only problem Lori really has this time around that she didn't have the other times around is a victim to stare her dead ass in her face. That's intimidating to Lori Vallow. Tylee, JJ, Tammy, and Charles were not there to confront her the way Brandon is, and she don't like that at all. She didn't like it when Kay was up there to confront her, and she doesn't like it that Brandon's going to. Too bad, Lori. They may as well let the guy go on his camping trip. They got plenty of other things to worry about. Getting Lori in the courtroom, getting her better. They know it takes a hot minute to get to the infirmary. If she caught it sick Friday and she put in an order to go to the infirmary, Lori wasn't going on Friday night. It's very doubtful. The judge knows that. The attorneys know that. Anybody who's been in a jail knows that. Anybody who's been to a jail or interviewed people who have been in jail. I mean, Jesus, it's not like you get to run to the ER and get your antibiotics and your juice at the damn pharmacy. Yeah. Well, she's butthurt about not getting her way over the judge. And then you couple that with being faced with Brandon, and I didn't get my way. Let me just throw a fit for a minute, have everybody talk about it. I mean, how much she likes being on the Dateline. Maybe she can get her a new interview with that little reporter from Arizona News or whatever the hell it's called. She can whine about how it's not fair. I didn't feel good, and hell, just wheel her one of them Taylor's to Business wheelchairs like I saw her win a while ago. Strap her in, throw a blanket over her, put a bucket beside her, and let's get it on, girlfriend. Yeah, they're gonna have to start over. If they don't get it going by Wednesday, that is the talk of the town right now. That they don't get it going by Wednesday, they're gonna have to start over. Sometimes her tactics that she thinks are working for her might just bite her in the behind. You know what I mean? A lot of times that will happen. It's that careful what you wish for syndrome, because you just might get it and then cry foul later. That's crazy. Yeah, telling the judge, you can come down there and see for yourself, judge. He's like, no, lady, I'll pass. Not stepping foot in that Maricopa County jail. Are you kidding? I put people in there. I don't want to go visit it. Honestly, the worst place to be stuck at is a jail if you don't feel good, because you're not going to get the accommodations you think you need. So let her suffer. If I'd have been the judge, I'd have been like, y'all want to get this lady some cold medicines from the pharmacy, like right now. Somebody run out and get them. Take her to the infirmary where she can have some juice. Let her lie down. We won't drag her out of the bunk. We'll give her another day to rest. She really wants everyone to feel sorry for her. Nobody feels sorry for her. I think a few people were like, "Oh, but yeah, I legit feel like she's probably got a cold. You can hear it in her damn voice. Like I'd be a fool if I said, "Ah, she's not sick." You can hear it in the woman's voice, like literally. But she's one of them whiners when they're sick. And if y'all have a spouse, you know what I'm talking about, women. I've known people like that when they get sick. It's just this whole other personality comes out. I cannot with whining. That's the worst thing in the world. It just wreaks havoc on my soul. Oh, I thought that thing was on silent. Look, if the infirmary doctor thought for a second Lori had a bacterial infection, he'd prescribe her some medication. If it's viral, you gotta let it run its course. You take cold symptom medication and you go on about your business, right? Like the rest of the world. Unless she's got some of those over prescribing doctors that just give you a antibiotic regardless. Take this just in case. Because we don't know what's wrong with you. Yeah, she's pathetic all the way around. She sounds really pathetic when she doesn't feel good. She's not getting no flowers from me. If I don't feel good, I just go to bed and like whatever it's all I can do, right? But damn, when you really don't feel good, you don't feel like doing anything and you want everybody to leave you the hell alone. I could imagine if she really is legit don't feel good. It would have to suck to be in her shoes right now.
Oh, yeah.
It'd be like, God, nobody cares about me. Poor Lori. She's living in a lonely world. She can call on Jesus. He's got her. She'll be all right. His healing hands shall touch her. We got about 10 more minutes, guys, and they should be coming back into court here in a little bit. They will come on time. What if Judge Bev had someone like Lori in her courtroom? Oh my gosh. Lori's always felt sorry for Lori. She didn't do anything wrong. She's been wronged her entire life. Well, she's got another day to get better, and then the judge can figure out what he wants to do with her. Sort it out, man. Sort it out. They are still at lunch spinning the fan. Let's see. Where am I at here? Yeah, give her one good zap. She'll be all right. She, she, goodness gracious, that lady. Let her feel like what it feels like to be jolted, right? Might make her feel better. Wonder why they never. Well, I don't. I don't know. I can't say it like that. I can't say. I wonder why they didn't swab and test John's wounds for DNA. I'm guessing because they assumed he was hit by a car and they never thought enough. I mean, you'd think they'd swab it regardless, especially if you don't know what happened right away. You never know. Well, look at there. Finally, I gifted some memberships. Thank you guys for all watching and being here with us, and welcome new members. Texas Ranger, good to see you as always. Missy Angels, Sirius Black, and Michael, and no way, Jose. Um, everybody's handles crack me up. I want them to get done with this witness after lunch and get another one on the stand so we can get onto some better parts of this trial. You guys, welcome to the lead investigator. We're working on some more content for members only. Um, Guys, if you don't mind, hit the like button while you're watching. I do appreciate that. I appreciate everybody coming in and watching with us and being a part of the conversation. That's always the fun part. So I think, Joe, wasn't Trina and the judge talking about coming in early on Wednesday, like at 9 versus 10 to try to make up for some time with Lori's case? Yeah, I don't know, Butterfly. You think they'll go into the accident reconstruction people after Dr. Russell to kind of keep that momentum going of that? It's like to keep the story cohesive, you know what I mean? I think they may go that route and then start introducing the witnesses to support their conspiracy stuff. And if that's all they're going to do is lend support to that theory, right? Because they're not going to come prove anything, but they're going to sure come out and talk about the possibilities, I think. Yeah, I've heard he's been seen at the courthouse, but I also heard he was in the courthouse. I'm like, yeah, but he's not supposed to be in, or in the courtroom rather. And he was not supposed to be in the courtroom if he's called to testify. So I don't know. That's the Lucky, right? The plow driver. I don't know if they actually have him on the list or not. They had quite a few people on the defense witness list to move through. Um, don't know if they still intend to call each and every one of them and to what aspect they would testify to, not all of them. So it'd be interesting to see how they do lay out their case, right? And in what order they call everybody in. Absolutely matters. Especially when you're trying to craft and lay out a well thought out, it's a story, it's storytelling, right? And I know they both came out and told me in openings, so they've been laying that out. Yeah, we got the updated witness list out of a document the other day, Rachel. I think it was the court document that I looked at, and compared it to the old witness list that came out in March in an article, and they had already added the 4 new people. So I don't know, but they don't. There's no. We don't know if they're going to call everybody on the list. I'd call him. He's going to be able to testify, right? That he came down with the plow, lights on, and all the things, and never saw John O'Keefe out there. And that's a key witness, in my opinion. You know, what did you see? Because you want to find the people who were actually out and about who may have seen something. You need to talk to those people. So he absolutely, if he didn't see anything, he didn't see anything, regardless of whatever. So he needs to come out and talk about that. Or if I was the defense, I'd call him up for sure and have him come say he didn't see anything. And during the time that he came through, the actual blizzard hadn't hit yet, right? It was still a lot of the light snow. And I get that throughout the night it was increasing, but not to a level where the tow truck driver couldn't see anything. I wonder if the jury feels like enough reasonable doubt's been established because the state, or it that would only work if they felt like the state's case was too weak and they don't 100% believe anything they put forward. If they have enough reasonable doubt right there that the case is done decided, right? And anything the defense can bring out to support that is just going to make it tenfold kind of thing. But I wonder how many of them felt like the state put on a strong case at the end of their case. Because I sure didn't. I didn't feel that. I tried to get there with the witnesses and get us there but they could never do that. Hmm. Do y'all think they'll call everybody that was in the house that night or just a couple of people? Like there's the four that I really care about listening to would be the McCabe's and the two Bryans. Ow. I almost poked myself in the eye. I wasn't paying attention. Oh, wait. If I hit a wrong button, it throws me off. I'm like, wait, where'd that come from? Okay. They're not back yet. They should be back soon. So hold this up just in case. We don't want to miss the beginning. It doesn't feel like the defense intends to call Proctor, does it? Who else would they leave off their list like that? I mean, I do get the reasoning behind that one, but you need to call some of those other people out. Let me unmute it so we can start hearing when they move around. I'm starting to get hungry. I don't know what I want to eat. Dolphin, you still with us? Are you gaming? It'd be nice if we knew some of their strategy and exactly who was on had an exact witness list. Who's next? Who's next? Who's next? We would be one step ahead of the game. We could anticipate it and get our popcorn ready if we need to. Mm. I don't know. Let me see, butterfly. Yeah, this, hang on, let me read that because I think some of that was coming down. It was on their court minutes yesterday, but it wasn't in the docket. Now it looks like it is. Defendant's motion to present a missing witness argument and request for subpoena instructions. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to allow for the use of a missing witness argument and subsequent instruction in her defense. All foundational requirements for a missing witness argument and instruction are met. Allowing Ms. Reed to present a missing witness argument would best position the jury to consider all of the evidence at issue, including what is missing from the Commonwealth's case in their deliberations. All foundational requirements for a missing witness argument and instructions are met. It is appropriate for the court to give a missing witness instruction where a party has knowledge of a person who can be located and brought forward who is friendly to, or at least not hostilely disposed toward, the party who can be expected to give testimony of distinct importance of the case, or to the case rather. The party would naturally offer person as a witness. If then, without explanation, a party does not call the witness to offer testimony, the jury may infer that the prospective witness would be given testimony unfavorable to the party. The underlying premise of a missing witness instruction is that a party's failure to call a prospective witness raises a reasonable interference and that witness would have provided testimony adverse to the party. I wonder if this is about it is, okay, hold on. It is about that. A trial judge has discretion to refuse to give a missing witness instruction requested by either party. However, a case supporting the need for judicial caution in permitting an adverse inference are appropriate when the inference is to run against the Commonwealth because there is no constitutional concerns to warrant the call for caution in such instances. Notably, the degree of judicial discretion may be lessened when it is the defendant rather than the Commonwealth who seeks approval of a missing witness argument. Michael Proctor, Brian Albert, and Brian Higgins are all available and friendly to the Commonwealth. Basic to the inference of the existence of evidence and physical availability of the witness and the likelihood that can be produced by summons of otherwise on a cite a court case. Michael Proctor, Brian Albert, and Brian Higgins were all listed on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of these witnesses. Additionally, the defense is informed that Brian Albert and the we got movement in the courtroom, guys. Informed that Brian Albert, Brian Higgins were both under subpoena by the Commonwealth. Michael Proctor, Albert, and Higgins are all friendly to the Commonwealth. These three witnesses testified. What they're saying is the prosecution has not called these witnesses. Are they missing? I need to finish the whole document, though. I'm hearing this in my ear in the background. It's distracting. We'll go over this again in a few minutes.
All right, Mr. Alessi, whenever you're ready.
Thank you, Your Honor. Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee, and I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
I have no further questions at this time, Your Honor.
Oh, okay. Mr. Brennan?
Could I inquire about scope?
See you inside, fine.
Something about the questions of the scope. All right. I'm still reviewing that stuff, Butterfly. Figure out why is some of that redacted? Oh. Guys, that link that Butterfly has there in the chat, that's to a Twitter post that has the document in there that I was reading from. It says that no one except for Brian Albert and Brian Higgins themselves can testify to their exact whereabouts within the home of 34 Fairview on January 28th and 29th. Sarah Levinson and Jennifer McCabe's testimony are not sufficient to support the claim that John O'Keefe never entered the curtilage of 34 Fairview, as they were not all together the entire time they were at 34 Fairview, leaving Brian Albert and Brian Higgins each with the opportunity to interact with John O'Keefe within the curtilage of the home without any other witnesses being aware. Specifically, no other witness has testified thus far or even would be able to testify in meaningful cross-examination about. This is a weird document. The reason for Brian Higgins visiting the Canton Police Department around 1:30 a.m. on the 29th. Additionally, no other witness has testified thus far, or even would be able to testify to and be meaningful cross-examined about. The reasons why Brian Albert, a trained first responder, and his wife did not come outside around 6 a.m. on the 29th, when their bedroom was mere feet from the scene of drastic life-saving efforts by paramedics and firefighters. Response to they went to the fan. I was like, well, there's movement. No legal or tactical explanation for the failure of the Commonwealth to call Proctor, Albert, or Higgins. Well, there's nothing stopping the defense from calling them either, honestly. So I understand what you're saying, what you're filing, but no, Beb's not going to pay attention to it. I want to see what this redacted part said. All right, they're moving around the courtroom. Yeah, Hank opened the door. He opened it. He's like wide open. Come on in. Cries foul only when it, hurts him and doesn't help him. An explanation is sufficient where the trial judge is satisfied that the circumstances thus offered would, in ordinary logic and experience, furnish a plausible reason for non-production. I want to get down here to this. Proctor's handling of the investigation and relationship with the very witnesses who should have been suspects in this case, and subsequent termination from the police department or state police to photograph some part of the house, and then a bunch of redacted bullshit. All right, we'll bring this up later in the chat.
May I?
Yes.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question, so we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Could we have Exhibit 1, please? Now, regarding the Munich article, That was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see 1 or 2 things that show up what I think might be upper and lower, so it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity, I believe that there's possibly 2 areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
Okay. There are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is, it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However, I'm
just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They named 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the... No, I don't agree.
Okay. I move to introduce this as an exhibit, please.
Mr. Leslie?
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Alessi.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do that.
Do you see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor, so in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event?
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan,
that true?
I have no details about the collision?
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Objection, Your Honor.
Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise, it depends on the location, it depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard in the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, if as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
Objection, Your Honor.
The objection system.
When you came to your conclusion, considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
Finally, Dr. Russell, you said during your differential diagnosis you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people's studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Sustained.
You don't know what his scope of practice is, do you?
Reel your guy in, Bev.
No, but I always look at where the person works that writes a report in terms of physicians and what their possible experiences are. You know, do they work in a medical examiner's office in Alaska or Hawaii or a big city or a little town? I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Yes.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the DeMunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of, Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism of in the methodology. Is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollack speak to that?
He does.
And what does Pollack say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin, and there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes.
Thank you.
Just step back a little bit.
Yep. Step back a second. Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw that.
Objection to commentary, and I'd like to be heard.
Why don't you bring the reports over? Okay.
I don't even know what to say about this shit show anymore. Or why they choose to drag out some of these witnesses forever and a day. Hmm. Bev's out of control. Rachel says, she's let her courtroom be out of control. The fact that she's let this go on as long as she has without interrupting and saying, okay, let's wrap this up, like she's been done to the defense before, it's a little annoying. It's actually a little more than annoying. Mm-mm-mm. Yeah, Rachel, she's probably wishing they would stop it now because they can go back and forth all day. It's the witness on the stand that's got to deal with that shit, right? They've hashed this out, like I've said, we've seen this play out with another witness or two. So I'm tuning them out at this point because they're not going to get. It's like pulling blood from a turnip. You only get so much before you're done. He tried to be all sneaky and bring up the body temperature, the battery temperature, all these things that had nothing to do with her diagnosis of the situation at all. You'd think it would annoy the jury. The way these juries perceive the judge and the different attorneys is a huge part of it. If they don't like you, they're not gonna want to fall in line with you, right? And so if you're up there making yourself like a big ass, that's your problem. The defense has gone out of their way to make sure they don't look like the big ass in the room. But here he comes in like, I don't care, I'll be the ass. Weird, but okay. Yeah. Out of the latest high profile cases, I've only seen one judge so far play fair. And even he almost crossed the line with me one time, only because he said something about he shouldn't have said, but it is what it was. I still like him. You, let me just say that's yet to be determined. I'm talking about Judge Hibbler. So far, so good. And I got real used to a judge just kissing prosecution ass all through the Delphi case. So this is child's play, honestly, compared to what went on in Delphi. It honestly is. It's sad to say it because a lot of y'all probably don't believe it, but it's true. Yeah, exactly, Rach. They have to, and that was another reason for the defense to bring on that newest attorney, who was the former juror, alternate or whatever, because she could give insight on what the jury was looking for as far as evidence and how they perceive things. If you come off as an asshole defense attorney, right, then you run the risk of alienating your jury. You want to be the friendly one.
May I return next to the witness stand, Your Honor?
Yes.
Thank you.
All right, let's get back at it.
May I proceed, Your Honor?
Yes.
Thank you. Dr. Russell, I am re-handing you this letter from Dr. Walsh, and what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
I'm going to have this marked for identification.
Thank you.
She's like, thank you, Jesus. Came and said my piece. Now I can leave.
Thank you.
Got a smile from the court reporter today instead of eye rolling and, oh my God.
And the next witness is who? Who's the next witness?
If I may, Your Honor?
Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you.
Okay. Karen's like, what? I seen all that, Karen. I'm watching you. Defense strategy and all. Okay. She didn't have her shit ready for this next witness. She's like, get my shit, man.
So you're going to step up, face the clerk, and raise your right hand.
You solemnly swear the evidence you give to the court and jury in the case down here and truth, the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, butterfly.
Good afternoon. All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dayton, Dayton Police Department.
How long have you worked for the Dayton Police Department, sir?
Since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
I believe he was there
2012.
the truck to take the Sallyport.
Is the Dighton Police Department an
Witness to their
autonomous
life.
police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
Collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature?
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual?
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger?
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, did you, I don't want the address, cameras are rolling, Did you respond specifically to a residence in the city of Dayton?
Yes,
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dayton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dayton to retrieve a vehicle that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle?
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company, with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Yes.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight,
Can you describe for the juror, by the way, which taillight are we talking about?
the right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you recall it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere
Okay.
in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection. Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side, where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Objection. Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have?
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is Exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area. This area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you.
Thank you.
Tread lightly, sir.
Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed?
Nope.
Or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at that moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but...
Did you at the time?
At the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did. The right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't?
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date?
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
Were you asked to describe the best you could the damage to that right rear tail light last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear tail light last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed,
Time has passed, yep.
that you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed,
Correct.
that your report was respectfully scant,
Correct.
that you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification for the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel to speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end?
The
good-looking one down there on the right?
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from last time you came into court?
No.
The photograph of the vehicle in Sallyport, or the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen indicted.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you
I'm-
testified at?
I testified that that was not the taillight the day that I saw it.
That's when you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dayton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged, it was cracked, and there was a piece missing but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So, in your memory, in June 10, 2024, was that vehicle's rear taillight had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dayton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right? Yes.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified. Objection.
I'm going to allow that.
And I should take a look at that. Could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dayton on January 29, 2022?
It's not in there.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Okay. Correct.
And you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
Objection. I'm going to allow it.
Over here. What did you talk about?
Excuse me. So that, okay.
Over here.
They're still at it. Mm. Sounds like he wants the witness to change what the witness says he saw or didn't see. So I've always known this guy testified to that. I just hadn't, because I didn't watch the first trial, but I've known about this. What do you guys think? The fact that he just saw a crack and a piece missing compared to what everybody else claimed was going on there is huge. But he testified to that the first trial, right? And it didn't make a difference to the jury, apparently. Hopefully they got somewhere.
You told us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when you met them at their hotel conference?
Other than that, they didn't go over my testimony. We just spoke about that I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year, this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably we're in June. early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably? Do you think you met them this year?
This year.
Do you know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talked about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV, and
Was it shown to you during your conference room meeting at the hotel?
it was not.
So you looked and studied and watched this case a little bit?
With all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you, I'm just asking you. Have you been exposed to this case since you made those observations indicted on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory? Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay?
Honestly, Butterfly, I don't know if I heard it all correctly because I'm only half-ass listening at this point. There's not a lot left they can. I understand what the guy says he saw. I don't have a reason to believe he's lying. So all this, yeah, the jury's probably right there with that. But they think that they keep these witnesses on there long enough, they'll break and admit they're just lying.
You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it indictment. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Okay. Before you proceed, Ms. Gomez, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look to compare to your memory?
Did I have a
Yes.
particular interest? No, I didn't follow this case
But you've seen this many, many times.
because of what is out there on social media and the news.
I understand. I understand. Who's way this way? Thank you. Stop, please. Do you see that white part of the back rear right taillight?
Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. Stop. Can you bring it back, Mr. Stone? Back more. Open, right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day?
Yes.
And when you got to the driveway, it had not been shoveled or plowed.
Correct.
There was quite a bit of snow accumulating and ongoing.
Yes.
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
Correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes.
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a red tail light there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
You have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustained as to the form, Mr. Jackson is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dighton, correct? Being called out to Dighton, to the residence of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
Do you remember it was this lady, pretty lady right here in the blue?
I do.
Do you remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dighton, while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sally Port in Canton PD? I'm sorry, in Canton, in the Sally Port, at the police station?
I wasn't.
At 5:30 p.m.?
Objection.
Sustained.
At any point, did you ever go to the Sally Port at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sally Port?
Objection.
Sustained.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection. Move to strike.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Objection.
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022, at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No,
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
Thank you. That's all.
You would agree that your memory has changed since last time you testified in this courthouse?
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dayton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up.
That's not evidence.
It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set. sir.
Thank you.
Quiet, please.
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witnesses. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1. Okay? Thank you.
All rise for the court, please. Close your notebooks and follow me.
So I wonder if her and the attorneys will have any discussions in open court, or they're going to take it away. Let's see.
Jurors, exit the court, please be seated.
So there have been some motions, I think, piling up. 2 I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that, but the only one that I did read is the reciprocal discovery. Ms. Gianetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time, I just don't know what you're talking about.
May we approach that?
Sure.
Maybe you should read those motions at the end of the day, Bev, and that you'd be caught up. You're going to rule on them after trial? That makes a lot of sense. Let's see. Dolphin, are you still here?
Yeah, I just said something a second ago.
Oh, I was like looking, I was like, where did it drop her down? Like, okay.
Yeah, Restream did drop me like a few minutes ago. Hmm.
Okay, sorry about that. Crazy. All right. Yeah, I wish they would get some of these rulings done. Get on with this business. I got tired a little while ago. I was like, damn, I could lay down and take a nap.
Yeah, I did fall asleep for a little bit there during lunch and whatnot.
Yeah, I felt like it. I just running a stream. I don't know if it's a good idea for me to close my eyes too long. I almost did that one day during Lori's. I was like, I can't. Yeah. Before I knew it, I was almost asleep. I'm not trying to have all that. I've never seen such a chaotically run courtroom though, where it's just we're winging it until we're not. And if each side had a good witness list, there shouldn't be any issues come up mid trial. It's ridiculous.
Wait, is this about a witness?
It's
What they're
always.
discussing?
Yeah, they still have the Barrows on the stand.
Hmm. I thought they were done with him.
Did they take him down and pull somebody? I thought he was still up there. I know I tuned out a second ago and I could have sworn he was still up there whenever I was multitasking. I didn't think they called anybody after that.
They haven't. I just think that she was like, that's a good spot to end for the day. I thought
Hmm.
that they were done.
Yeah, they're done for the day as far as all that goes. But as far as if they're going to call him back, I don't know if they're going to call him back tomorrow or not. I don't know if they're done with him, or what they're doing.
Yeah, see, Rachel said he was released. That's what I thought.
That's cool, good, because I'm ready to move on. I got totally bored and tired of hearing it. Hmm. Let's see. Yeah, there wasn't a lot left they could get out of this guy either. Like they just been picking him to death for no reason. Yeah, he didn't have any reason to lie, did he? Either way, Rach, come in. It's like like earlier with all the other witnesses. They're not all going to be a willing participant in anything. They're just here to tell their stories and tell what they saw. He's just telling what he saw and didn't see.
Oh, yeah, Rachel, that was too funny. When he said, I don't live under a rock.
Mhm.
Yeah, these people are just ridiculous.
It is a little ridiculous sometimes. I can't even with half of it. It doesn't intrigue my brain anymore, especially when they get up that monotonous line of questioning that just beating this fucking dead horse back and forth. I wonder. Hold on. Trying to make the hotel look shady was, you know what? That prosecutors made him so whole self look shady. He's just got to win at all cost. He proved that when he talked about John's brother-in-law. So you keep on going out there trying to say that the defense is the bad guy here, right? It appears it's the other way around in this case.
Hey, thank you so much for watching the Karen Reed trial with us, but I wanted to tell you guys about something real quick. We talk a lot.
Boy, old things get brought up in cases when it gets quiet. I mean, really old things start coming back to the forefront. Goodness, I don't know. I'm going to pull up this other. Hang on, dog. She's like, it's usually that time of day, lady. You take me outside again. The cops that were telling the lies are all tied together in their little conspiracy deal. This guy's got nothing to do with any of that, right? Okay, that's what I thought. I pulled up a different. Okay. And those cops that we did see get up and testify that we can tell they're probably lying, they all seem to look defeated, halfway through their testimony. Especially Buchanan, right? You could just see it in his face. And they know that that Proctor shit made them all look so bad. Whether they did anything or not, it made your whole entire department look horrible. Only way this guy would have lied about anything butterflies if he was on the take with the rest of them. Then, of course, they'd have had the Dighton guy in the bag as well. Oh boy. So the judge just mentioned that witness, Karina Kalakithis. Is that her name? So there's a report out. Take it with a grain of salt. Sources are reporting that that particular witness for the Commonwealth last trial will testify with a lawyer present that Jennifer McCabe told her there was ring camera footage of John O'Keefe being hit by a car in an attempt to convince her to turn against Karen. This is completely in line with McCabe's manipulative behavior towards many other witnesses in the days after O'Keefe's death. WBZ also reported this lie on February 1st. the day they were at D&E Pizza, and Matt McCabe texted in a group chat that Chris Albert should tell them the guy never came in the house. Huh. Interesting. Now I want to hear from this Karina. So if she testified first trial, is she changing testimony this time or bringing her lawyer in with her? Like, oh, Jim McCabe. So did Jen tell her there was ring cam footage? Are they talking about the cop's house across the street? They've claimed that it didn't have ring cam footage. Hmm. Maybe they'll come back. Maybe they'll get it together, guys. I don't know who that witness was. I'm going to have to go watch some stuff later. They all have amnesia. Yeah, they got something way worse. They got a big embarrassment. We got to keep the cover up going on so we don't all look bad, kind of thing. I don't even know these people. They're a little wacko. Okay, here they come again.
I guess they're all just packing up.
It looks that way because they probably can't get nothing settled. She's not going to rule on her motion. She's going to take time to read this and read that.
Mm-hmm.
These non-reading judges, like I can't with them anymore. Um, I don't know what she does in her judges' chambers. I don't guess she reads the materials that come in with the motions. So I guess they'll be back in the morning, Wednesday. Back in the morning around 8 a.m., the usual time. I can't look at that fan spinning all the time. It will make me dizzy. Can post what in Discord? Did Rachel have something? Oh, what I was reading from? Yeah, I will. I gotta go find it. Don't know if it's true, and the source, I'm just saying. Oh, that's not him. It. but I'm inclined to believe some of this stuff because I've been monitoring some of the stuff coming out. Hang on, I gotta find it again, Butterfly, because I'm not sure the account's exact name. Oh, got it. Okay. Okay, found it again. It took a minute because there was like a bunch of posts. Apparently, I didn't realize all that. Okay, I'm just gonna drop it in general chat. Yeah, there you can see it. I'm not familiar with this witness, so I might go back tonight and look at her old testimony just to see if it how it compares, or to get a feel of what it might be like. You know what I mean? What's going on with that? Um, oh, I hit the wrong thing again. I feel like I need a nap now. It's a long afternoon with some of these darn witnesses when they don't get to anything. Repeated line of questioning over and over. Okay. Because I think Joe has a members only live tonight. Lori Vallow. I feel like, let me go look what he said. He was talking about it last night. I don't know if he has the show set up yet or not. No, I don't think he's got, as far as I can tell, he doesn't have one set up for tonight yet. So I don't know what he's planning on doing with that. And I guess we'll see tomorrow if they bring Lori back into jail, back into court to get her final trial underway. We'll have to wait and see how that goes. Again, guys, everybody, thanks for coming in and joining in with us. I'm gonna go chill out. I might just take me a nap. Like I really feel like I need to take a nap.
Okay.
It's been a long one, man. I just checked the docket again on both Stearns and Koberger, and nothing new. I'm checking that Stearns one a couple times a day because I really want that judge to make those damn orders so we'll know what the hell's going on with that.
There were a couple new things for Idaho. Danger sent it to me, and yeah, got me
There's
all excited, but it was nothing. You can.
It's nothing. Yeah, it's jury instruction stuff.
Now it's a 23rd supplemental request for discovery.
I was just looking at it. Let's see.
And then a request to seal the exhibit that goes
Yeah,
with that.
there's stuff we can't see on there. I mean,
Mhm.
because I've checked it a couple times a day, and there's nothing exciting that we need to talk about, right? That's not sealed
Right.
yet. Yeah, yeah. No, waiting on anything good. Yeah, just the only thing come down still is sealing stuff, jury instruction, supplemental witness list, mitigation list. Yeah, all that's still there. But
I
yeah.
am curious about what that 23rd supplemental request for discovery is, though.
That one goes back. It ties to where did it go? I was looking back. I'm putting together some documents for certain things, and I was looking at some of these this past week. The 23rd. I'll have to go back and look at it later. Let's see. But yeah, nothing exciting and new come down. Nothing outside of a 1 or 2 page seal this and seal that.
Yeah, it says it's information, evidence, and materials outlined in Exhibit 5.
Mm-hmm.
So there's a bunch of something that they've asked for again.
Yeah. It's still it's a supplemental request though, right?
23rd.
Yeah.
Yeah.
And I don't know if it's going back to one of their ones they already have asked about. That's what I'm wondering. I'll look at those. Let's see. Yeah, I want to look at something else to do with that in a little bit and see if I can look at some of the stuff. So Joe, you got, yeah, I got the copies of those documents that went out today. All right, so go, guys. Joe's going to do that over there later. I don't know if I'm going to come back on tonight or not. It really depends on how something goes down later. If not, we'll be back in the morning at our usual time around 7:45 to get us in here by 8 a.m. to get the court underway. And we'll wait and see if they're going to get Lori's trial underway tomorrow. We'll figure that out. And we'll keep an eye on the dockets that we're watching for anything new to come down on those as well. Until then, I will see you guys back here in the morning unless something comes up later.
Thank
Have a
you
good one,
all
guys.
for watching this
Good night.
video. Please like and subscribe and follow. Much love from Little Yas to